At this time, the court calls State of Wisconsin versus Stephen Avery case number 05CF381. We're here this morning, outside the presence of a jury at this time, for a continuation of a trial in this matter. Will the parties state their appearances for the record, please?
State appears by Special Prosecutors Ken Kratz, Norm Gunn, and Tom Fallon, Your Honor.
Good morning, Your Honor. Attorneys Jerome Buting and Dean Strang appearing on behalf of Mr. Avery, who's present.
All right. And I understand, Mr. Buting, that you wish to be heard outside the presence of a jury before we commence cross-examination of the State's last witness.
I do, Judge. At this time, I'm making a motion to suppress and to move to strike any of the testimony and evidence regarding the results of the bullet fragment FL that was testified to about yesterday. The reasons are I'm renewing the motion that I filed in this court entitled Defendant's Motion to Assure Fair Forensic Testing, which was filed on March 6 of 2006. In that motion, I ironically, or maybe not so ironically, predicted that there would be potential of contamination and complete consumption of evidence that would potentially hamper the defense ability to get a fair trial and to be able to meet the state's evidence. The motion was filed on March 9th. The state replied, ironically, arguing that the state crime lab was unlike other crime labs that I had cited from other parts of the country that had problems with contamination or outright fraud. The state replied arguing that there's no evidence of any contamination history or record in the state of Wisconsin's crime lab, and that having a defense expert present, again, ironically, would increase the risk of contamination. Now, here we hear that the state crime lab brought in new trainees, which increased the risk of contamination during that critical test, when we could have very easily had a defense expert also there and observing at a minimum if she was going to use up all the sample and thereby prevent the defense from retesting it itself. The motion was heard on March 17th, 2006, and that's before the bullet even arrived at the crime lab. Now we hear 2 to 3 weeks later, Ms. Culhane does this extraction on the bullet and uses it all up, contaminates the testing process, and we have no recourse other than relying on cross-examination to try and point out those mistakes. In the motion hearing, which was heard on March 17th, Mr. Gahn made a point of saying, one of the things we had talked about is that our expert had in prior cases been able, particularly in Illinois crime lab, been able to be present when there is an instance of sort of a one-time test where there's not going to be enough for both sides to later test. And Mr. Gahn says, in all candor, I'm quoting from the transcript, in all candor, I will admit to the court I have heard of cases where that is done, or there's an agreement between the defense and the prosecution to send the item for independent testing. But those generally are cases where there's one critical piece of evidence and there will be total consumption of that evidence. Skipping down a little bit, where it's just one piece of evidence that could be inculpatory or exculpatory, and the defendant has no other comparable means of getting that evidence analyzed. Clearly, Mr. Gahn was on notice that if that situation arose in this case and that a critical piece of evidence was going to be completely consumed by the state's tests, that some effort should have been made to assure fair forensic testing, which is what we asked for in our motion. Instead, we heard what happened yesterday. The crime lab analyst consumed the entire sample and denied us the opportunity for a retest, which all along Mr. Gahn has been arguing is the solution. just retest. We're happy to have you retest. But we can't retest when there's been an extraction that's contaminated and that was made clear yesterday. So the court, by the way, also in its decision, made a point of noting that the court was not aware that our state crime lab has been involved in incidents of mistakes and contamination, things of that sort, unlike other crime labs. Now it turns out that the state knew back then that the crime lab was keeping a contamination log, and they knew that, at least by then, there was probably 75 incidents on that they had reported of contamination. And that wasn't disclosed to the court or to the defense. It was only, in fact, that wasn't disclosed even in our original discovery request for the bench notes and lab sheets and all of that stuff. We had to make a separate independent request for a contamination log, if one existed, before we got that information. So I think the decision that the court made in March was based on faulty information. I think the state should bear the penalty for that. I think that shows bad faith, both in the failure to disclose that there was a history of contamination at the time we made this motion and argument, and bad faith in that even after it was made clear to the court that the defense had concerns about a single one-shot test that would consume everything, the state nevertheless went ahead and did that, and did it while training somebody, resulting in a contamination. So for all those reasons, I think the court doesn't have to decide this today, but I want to put it on the record today. For all those reasons, I am renewing my motion and asking that the test results be suppressed, that the jury be instructed accordingly, and we can decide this at a later date, but certainly, obviously, before the case is sent to the jury.
Who's going to be responding for the state?
I will, Your Honor. I would ask to be given some time to reply to this. Just hearing this now, I need to review the transcripts and review the motions that were filed.
All right, very well. The court will then take the renewal of this motion under advisement at this time and give the state a chance to reply later. I will just make some notes here. Anything else before we bring out the jury? If not, we can bring the jurors out at this time. You may be seated. Members of the jury, we did have a matter to take up on the record outside the presence of a jury before starting today. That has now been completed. At this point, we'll have Mr. STAHLKE return to the witness stand and the defence may begin its cross.
Please raise your right hand. Please be seated. Please state your name and spell your last name for the record.
Nick STAHLKE. STAHLKE is spelled S-T-A-H-L-K-E.
Good morning, Mr. STAHLKE.
Good morning.
I have got your curriculum vitae, fancy word for resume, with me, and it looks to me that you have had what we might agree is broad experience as a forensic analyst?
That's correct.
Before you went into work at crime laboratories or forensic analysis, you spent several years as a pharmacy technician?
Correct.
Got a basic familiarity with pharmaceuticals and controlled substances?
Yes.
Your first job as a forensic analyst was for the state of Idaho?
That's correct.
Hence the work you described doing teaching at the Northern Idaho College?
That's correct.
You did a broad range of forensic analysis with the state of Idaho?
The state of Idaho has criminalists, and criminalists are basically generalists. They have more than one specific duty in a crime lab.
Maybe not quite close enough to the mic there, but the word is criminalist?
Correct.
Okay. So, and as you say, sort of a general range of forensic and analytic tasks that would be assigned to a criminalist generally.
Correct.
Wisconsin specialises a little bit more than that, correct?
That's true.
But you became what is called a principal criminalist for the state of Idaho?
Yes, I did.
Meaning you had obtained some experience across a range of forensic topics?
Yes,
And got a promotion in effect.
that's correct.
When you joined the Wisconsin State Crime Laboratory, drug identification was your first area of work?
Yes, that's true.
Drug identification. We don't need to do a lot on this, but what that means is that in cases where someone is charged with possessing or distributing illegal drugs, what we call controlled substances, you would be the one who would analyse an unknown white powder, let's say, and give an opinion on whether that contained, for example, cocaine.
That's correct.
Or whether a leafy green material contained marijuana, or the active chemical in marijuana.
Also correct.
And after a stint doing that sort of drug identification work, you moved into what are called question documents in your line of work.
That's correct.
A question document would be what we might think of sort of in everyday life as handwriting analysis.
That's right.
So in a case where someone was alleged to have forged a cheque, let's say, you might compare the handwriting on the allegedly forged cheque to some known handwriting of the checking account holder.
Or a suspect in the case, yes, that's correct.
Or a suspect in the case, correct. And render an opinion on whether the handwriting looked to be more like the suspect's or more like the innocent account holder, for example.
Correct.
That sort of examination of question documents has been the largest or longest area of your work for the Wisconsin State Crime Laboratory?
On a full-time basis, yes, that's true.
Something like, oh gosh, what are you going on, 13 years now of that?
Just under 12, I believe.
Okay, 1994, thereabouts.
94 is when I started my 2-year training. It's basically an apprenticeship program, so it was 2 years of that before I could actually examine the actual cases and question documents. So I've been working on cases independently since 96, under 12 years.
And then somewhere along the line, you picked up some training and experience in blood spatter.
Yes, I did.
Or blood patterns, blood stain patterns.
Correct.
Now, here in this case, you weren't called in to look at question documents, I assume, right?
No, that's correct.
You weren't called on to look at drug identification.
That's correct.
But your bloodstain experience and knowledge was called upon.
Yes, it was.
Now, in approaching potential bloodstain and bloodstain pattern evidence, this is close-up, eyeball sort of examination as a starting point?
Yes, it does take some close examination.
You don't do this, in other words, typically from photographs, if you have access to the actual object to be examined.
Look, we look at photographs only when we do not have the item to actually examine.
Right, and this will require, as I say, sort of close work, at least at times, getting up literally close to a stain or suspected stain.
Yes.
Now, in doing that, you have a concern, not specific to any case, but in general. Good practice would suggest a concern that you not contaminate the bloodstain or suspected bloodstain you may be examining.
Yes, that's true.
Further, on any given object, blood staining the object may be only one of the possible trace types of evidence available on the object, correct?
Sure.
All right. There may be fingerprints on some objects, true?
Yes, that's true.
Or maybe DNA.
Also true.
Any number of possible things that could be on the object as well as the stains that are of interest to you.
Yes.
So you take precautions to try to reduce the risk that you would accidentally, unintentionally, contaminate the surface or the object, the area you are examining.
Our goal is not to contaminate the scene, no.
Among the precautions you take are wearing the latex gloves you described.
Correct.
And this sort of thing over here.
Yes.
Surgical type gloves. You also wear a lab coat or smock?
Correct.
Do you wear a face mask?
Not always, no.
All right. Booties?
When in a scene, yes.
When at an actual suspected crime scene?
Correct.
Okay. And these things then tend to keep you from inadvertently transferring anything from your body, so to speak, to the scene or the surface you are examining up close.
That, as well as transferring something from the scene onto our bodies, correct?
That's exactly where I was going, actually.
Correct.
And I'm glad you brought that up, because the second purpose, then, is that you don't want to be contaminated either.
Correct.
Correct. And it would not be uncommon at a crime scene for you to be walking into an area where there may be unknown hazards.
Correct.
If I'm not talking about hazards from an armed person, presumably law enforcement officers sweep and secure a crime scene before you would arrive.
Oh, yes, they do.
But there may be what you could call biohazards.
Correct.
Viruses, conceivably.
Yes.
I mean, you in particular are working in close proximity to blood.
Correct.
Blood from unknown sources?
Correct.
So things like hepatitis C or HIV, you know, any number of possible biohazards are something you have to be aware of.
Well, yes.
There may be other dangerous chemicals or what have you at a given scene.
That's possible.
And one of the things that is true about your work is you are coming in dealing with a range of possible unknowns and trying to make some of them known.
Yes.
You are trying to recover evidence and assign some meaning to it, if you can.
Yes.
So the protective clothing and gear you wear is designed both to reduce the likelihood that you would contaminate the scene and to reduce the likelihood that you would be contaminated by the scene.
That's correct.
Now, blood in specific sometimes is present in very minute quantities.
Yes, it is.
For example, you described yesterday, and I don't have these available to show you on the screen unless I really need to bother Mr. Kratz. I won't. But you showed us what you described as some impact staining on the rear cargo door of the Toyota RAV4 here.
Correct.
Some of those spots, of course, were visible to the eye, particularly when we zoom in on the photograph, correct?
Yes.
But even those, many of them are just very small, sort of pinpoint specks of blood, correct?
Many of them were, yes.
And when you have blood being flung or cast off so that it has an impact with a surface, these can be very small droplets, some of them.
Yes, they may.
Some are larger.
Absolutely.
But in looking at a surface like the cargo door, you are aware of the quite real possibility that there are small specks of blood too small for you to see.
The stains that are not visible to the eye would not necessarily have any significance to the pattern.
But they may be there.
There may be.
Particularly, let's again talk about these sorts of impact stains. Your experience, or from your experience, you know that if, for example, a bloody head, someone with blood in their hair, if their hair is being flung and droplets are being cast off, you may get a range of size of those droplets.
Yes.
Right down to droplets so small that you wouldn't see them unaided with the human eye.
We would look at any stains with magnification if necessary, but I don't know of any. I have no experience with the stains that are not visible. Unless they are, they have been removed, either through washing or wiping, and then those would be considered latent stains, and those stains, then we can visualize through the use of other chemicals.
Well, before we get to other chemicals, and let's go back. Remember the CD case?
Well, yes.
I don't have an exhibit number on the CD case. Is that something you have here, Mr. Kratz?
Yes, 92.
Terrific. Is that something you could pop up there? Let's go back to Exhibit 292 with Mr. Kratz's help. What you told us about yesterday is that we could see part of the stain there.
Correct.
You still have your laser pointer?
No, I do not.
I don't know that you will need it, but you told the ladies and gentlemen in the jury box to your left yesterday that something like 50% of the surface area of that CD case was covered in blood.
Well, my recollection is that a large portion of this CD case had a light coat of what appeared to be red-brown stains.
All right. Now, if we don't see those, we don't see 50% of that CD case covered in a light coat of red-brown stains. That's because the stains are very small.
Oh, no. In fact, in this particular case, it was more of a white pattern or a smearing of that, of blood on that, the rest of that CD case. That is not observable on this photo. So, in other words, it's a very light coat of what appeared to be a red-brown stain.
And if that were not observable to the naked eye, but you suspected it or wondered about it for some reason, you have at least one chemical that will assist you in seeing something you otherwise might not see, true?
Oh, yes, correct.
Luminol would be the typical chemical?
Yes.
That's just something you spray on and then observe under ultraviolet light.
No, it's chemiluminescence that gives a light, faint, yellowish green glow in complete darkness, so you don't need additional mechanical help.
Okay, but you do need darkness.
That's correct.
And then you will see this glowing where the naked eye may not pick up blood.
Correct.
Luminol, of course, is not specific for blood.
No, it is not.
Bird droppings and a number of other things will luminesce with luminol, correct?
Yes, there are other things that will give it a false positive, yes.
But what it does is it signals you to look harder or do a little bit more examination of the surface.
Now, typically we use luminol only as a last resort when we feel that there was some attempt to clean up some blood. So in a particular examination, when we're initially looking for blood stains, we won't use luminol as long as we can visibly see them.
You did not use luminol in examining the Toyota?
That's correct.
At any time?
Not that I know of, no.
That you know, or on any part of the Toyota?
Correct.
That is, you saw no indication that anybody had tried to clean up or wipe away bloodstains?
Well, there was enough visible blood that wouldn't require that we use the luminol in this for this examination of this vehicle.
You also saw no evidence that anyone tried to clean up or wipe away bloodstains?
I can't say that that's necessarily true. The amount of blood that was on the molding or the side of that back storage area would indicate that there should have been additional stains on the carpeting that I did not see.
And are you here telling us that someone cleaned up the carpets in the rear cargo area?
There's a possibility of that, but there's nothing that indicates that occurred.
Nothing at all that indicates that occurred, is there?
Only the fact that the lack of a lot of staining on the carpeting area would indicate there is a possibility that there may have been some attempts to clean up the blood.
All right. And do you think it would have been easier to clean up carpeting in the rear cargo area so that no blood was visible than it would have been to wipe plainly visible blood off the plastic? Well,
that would make sense, yes.
Easier to clean the carpets?
No, I would say that if you're making attempts to clean all the blood in a particular scene or a vehicle, you would try to clean up all the blood and not just those areas that are on carpeting.
You mean the plastic that was sort of a plastic composite, the wheel well cover on the inside of the cargo area?
Correct.
Correct. That presumably would have been wiped off with a rag, a towel, a paper towel, something?
Right, it could have.
The carpet would have taken something that would get into an absorptive surface, like a carpet.
I don't understand your question.
Some sort of cleaning solvent or something to get in. I mean, the carpet was an absorptive surface.
Yes, it was.
All right. And in any event, you have no idea at all whether anyone tried to clean blood off the carpet in the cargo area or not?
No, I do not.
No idea whether anyone tried to clean blood from any other surface in the car?
No obvious evidence of that.
What you do know is that the total blood you saw inside the car, forward of the rear cargo area, okay, so I'm talking about the passenger compartment of the car, if you will.
Okay.
The total blood you saw there was, you know, if we could somehow put it in a little jar, was a tiny quantity of blood.
If you try to quantitate the amount of the number of stains you could get from a small amount of blood, it could be a large number of actual stains.
From a very small amount of blood.
That's correct.
And you have no way to give us an accurate quantity of the blood that made the stains you observed in the passenger compartment of the car.
About the only thing I can tell you is that a natural stain would, or a drop of blood, contains about, half a millimeters.
And do you think 0.05 millilitres could have made every stain you observed in the passenger compartment of that car?
No.
Twice that?
It would have been much more than that.
And what do you mean by much more?
It probably would have been, if you want me to quantitate the amount of blood that was required to use those or produce those stains, I would have to guess between 1 and 2 millimeters.
1 and 2 millilitres?
Correct.
Okay, that's a guess.
That's a guess.
But based on your experience?
Yes.
And your training?
Right.
You did at various places in the passenger compartment. We can take that down now. We can probably take that photo, Exhibit 292, down now if you want. Just to be clear here, Mr. Butin reminds me, when you say 1 to 2 millilitres of blood, you are not including the blood staining in the cargo area.
That's correct.
So just the passenger seats forward to the ignition area.
That's correct.
All right. Now, you did do some phenolphthalein testing?
I did not, no.
Did you see that done by someone?
Yes.
All right. Done in your presence?
Correct.
And what does phenolphthalein testing involve physically? What is one doing when testing with phenolphthalein?
Physically, you use typically a cotton tip applicator and collect a small portion of what you think is a probable blood stain. You then add a drop of phenolphthalein and a drop of hydrogen peroxide within the oxidation process or reduction process. And with that, then, the combination of those chemicals, you see a color change, a pinkish purple color.
Right, on the head of the swab.
Correct. For positives, probable positives.
And you are adding the phenolphthalein and the peroxide with an eyedropper or something like that?
Correct.
So this process, again, requires actually getting up to the stain and swabbing part of it with a swab?
Yes.
Did you physically have to get into the car here to examine the blood stains you have described? And let's start again with the passenger compartment, forward of the rear cargo area.
I did not have to crawl into the vehicle. I had to lean into the vehicle in order to see some of the stains, yes.
All right. For example, which stains did you have to lean in to see?
The stains on the front of the passenger the driver's front seat and the passenger's front seat, and also to get a good look at the stain just underneath the ignition. I had to lean in and look around the steering wheel in order to see it.
In leaning in, you took care to prop yourself at places where you did not see any bloodstain?
That's correct.
And, of course, you had the latex gloves on?
And coveralls, yes.
Now, eventually, you discovered that either one or both battery cables were disconnected?
Correct.
Under the hood?
That's true.
You were the one who opened the hood,
Yes.
which required releasing a lever inside near the driver's left leg,
Yes.
and then popping the hood latch when that appeared through the grille at the front of the car.
Correct.
Lifted the hood, propped it with the metal rod, and looked at the battery posts.
Correct.
One or both of those was disconnected.
If I recall, they both were disconnected, but I know for sure one was.
And the one we saw in the photo yesterday, I saw some reddish or reddish-brown discoloration on or near the battery post.
Correct.
Was that something you tested?
Nah.
That you described was not suspected blood.
Well, I believe there was actually a phenolphthalein test done on that, but it was not positive.
Okay, so whatever that was, wasn't blood.
Correct.
Now, you were still wearing the same latex gloves when you opened the hood.
The same latex gloves that I put on prior to opening the hood?
Yes.
Yes.
Okay, one of the things, in going back now, when you are doing your visual examination of the car, okay, one of the things you are aware of is the possibility of latent fingerprints.
Correct.
A latent fingerprint is a fingerprint that is left on a surface.
It's a fingerprint that is not visible to the naked eye until after it's been actually raised through some type of process.
And you were aware that this car was processed for fingerprints?
It was in the process of being examined for fingerprints as I was looking at it, yes.
And this was Mr. Riddle?
Correct.
Mike Riddle?
From our lab.
From your lab?
Yes.
So he and you are working on the Toyota simultaneously?
That's my recollection, yes.
And what he does is examine the car and treats it with some substance to try to make, as you say, these latent or invisible fingerprints appear to the naked eye.
There's a number of processes that the identification uses to do that, yes.
And you may have had some experience with that as a criminalist in Idaho, but that's not your field today.
That's correct.
Were you able to see, though, as you did your walk round of the car, or spent your time around the car, whether Mr. Riddle raised latent fingerprints on the top of the spare tyre wheel cover outside the rear cargo door?
I don't recall.
One way or the other?
No.
You do remember him encircling the car and processing it for latent prints?
I know that he was present while I was working on the vehicle.
One of the limitations on what you do is, in assessing a bloodstain, if the blood is dry at least, you ordinarily cannot give an opinion on when the bloodstain was left.
Not absolutely, no.
Can't give an age of the bloodstain.
I can give a feeling as far as the age of the bloodstains because the bloodstains change in color after a period of time.
But that's, as you say, a feeling.
Well, there's some basis for it as far as I don't have any examples of it, but the longer a stain is exposed to the atmosphere, the darker the stain becomes. So if you have a bright red stain you are examining, you can have a good assurance that that stain is rather fresh.
At some point, the darkening stops.
At some point, yes, it does.
And beyond that point?
Then you have no feel for the time.
Right.
Correct.
And when approximately does the darkening of a bloodstain stop?
Nah, I don't know the exact absolutes on that.
Are we talking days?
Probably more like weeks. Weeks. It has a lot to do with the environmental conditions as well.
You here made no effort to determine the age of any stain that you saw in the Toyota?
There was no requirement for that.
You made no effort to determine the age of the stain you saw in the Pontiac Grand Am, for that matter?
No, there was no requirement. These stains were rather fresh looking.
You say rather fresh looking. They were dry?
Correct.
They were reddish-brown.
Reddish, yes. And we use reddish-brown as a general term. There were probably more red than brown.
None of them bright red.
That's correct.
The other thing that you can't say in examining a blood stain is when it's a contact or transfer stain, you are not able to say what surface with blood touched the clean surface without blood with any reliability.
Without any reliability. There's rare occasions that you may be able to determine that. A fabric impression would leave an impression that appears to have the weave of the fabric that touched that surface. But otherwise, you might be able to get the transfer or the outline of a weapon, like if somebody's wiping the blood off of the knife blade, you might be able to see the outline of that knife blade. But it is only consistent with that object coming in contact because you can't necessarily identify it completely.
Right. And let's use an even better example. When you get in, every once in a while at a crime scene, you will actually get a fingerprint or a thumbprint that's left in blood.
You will have some ridge detail in blood, yes.
All right. So in that circumstance, you either can tell that it was the bleeding finger, or at least that somebody put a finger in fresh, wet blood.
It would be the surface of the ridge. The area that contains ridge detail has contacted the surface, yes.
So again, either that finger, thumb, whatever, is bleeding, or it's not, but it contacts the fresh blood.
I guess I don't understand your question.
If there's a bloody fingerprint, okay?
Mm-hmm.
Either the finger that left it is itself bleeding.
Oh.
Right? Or the finger is not, but the finger is put into wet, fresh blood.
It would be the blood transferred from that particular finger. So that finger either is bleeding, in your case, or it has contacted blood and then transferred it onto another surface.
You didn't see any bloody fingerprints here?
I don't recall seeing any, no.
No. And if what you see is what you called a passive drop, passive stain, that could be a drop of blood from some part of a person's body that's bleeding.
Correct.
It could be a drop of blood from sort of eyedropper that's used for phenolphthalein.
It could be, yes.
It could be a drop of blood from a pipette.
Well, yes, it could be.
Could be a drop of blood from anything that's capable of producing a drop that gravity will cause to fall to the surface.
Yes.
Likewise, when you see a swipe, that could be from a bloody elbow, a bloody finger, correct?
It's a bloody object, anyway, that has blood on its surface and is moving across an unstained surface.
So, again, whether that's part of a person's body or a Q-tip or a stick of wood or anything else that's a bloody surface and moves across the clean surface, you can't say.
Well, if it was the difference, if you're trying to distinguish between a Q-tip and an elbow, let's say, you're looking at a much difference in surface area that would have caused the same.
Sure, but by the same token, if it's the tip of a pinky and it's about the same as the tip of a swab, you wouldn't necessarily be able to tell the difference between what left the contact or the swipe.
Not necessarily.
Now, if a person were actively bleeding, the term you used yesterday, a person were actively bleeding from a hand, okay, and had contact with this car in various places, ignition, door threshold, whatever, you might well see fingerprints, wouldn't you?
No, not necessarily.
Not necessarily, but you might expect to see fingerprints.
I have no expectation to see fingerprints from somebody that is just actively bleeding. In fact,
including if there's...
I don't know that I've ever been to a scene where there's been active bleeding or passive drops in the same scene, seeing bloody foot, bloody fingerprints.
All right. But you described more than passive bleeding, haven't you, in that passenger compartment of this car?
Oh, there's contact stains and passive bleeding as well, yes.
Right. The contact stain, which is what you called it, over the ignition area, for example.
Below the ignition, yes.
That was not what you called passive bleeding.
No.
That was actual contact.
Correct.
And if someone was actively bleeding enough so that the surface of his skin rubbed against the surface of the car and left that contact stain, then you might be at risk of leaving a fingerprint in the car as well.
I would not have any expectations of a fingerprint left there, depending on the orientation of the cut. If the cut is on the back side of a hand or on the elbow, I wouldn't expect that person that is then actively bleeding, leaving bloody fingerprints.
Sure, understood. But when you say, if you assume that a contact stain is left by someone who is actively bleeding, one of the things you can say is that the person may not have had a glove on or something covering the active source of bleeding, correct?
That's probably true.
All right. So there may not have been a Band-Aid.
Correct.
Or a bandage.
Correct.
There may not have been a glove.
Probably not.
All right. There also could have been a glove, correct?
If he is bleeding profusely, there is a possibility that the glove has a hole in it or a cut in it and they are bleeding through the glove.
Or just soaks through the glove.
Sure.
But now we're talking about probably profuse bleeding, as you say.
More than likely.
Now, tell us what blood you found on the exterior door handles of the Toyota.
I did not find any blood on the exterior door handles.
Tell us about the blood you found on the interior door handles.
I did not find any blood on the interior door handles.
How about the blood you found on the steering wheel?
I did not observe any blood on the steering wheel.
Did you look?
Oh, yes.
No blood at all on that steering wheel?
I didn't see any visible blood on there, no.
See any blood on the gear shift lever?
I don't recall that I did, no.
This was an automatic transmission Toyota, as you remember.
Right.
So there's a lever somewhere in the centre console?
Yes.
With something that one has to squeeze to take the vehicle out of park?
Correct.
You examined that closely?
Oh, yes.
Saw no sign of blood?
Not that I recall. Nothing observable or visible.
When you're examining a pattern of blood staining, this is something that requires some judgment. Is that fair?
Yes.
Because it's a matter of interpretation.
Correct.
I mean, you are typically not fortunate enough to have a videotape of what actually happened to leave bloodstain patterns at a scene.
Not at a scene, no.
So one is sort of reconstructing based on judgment.
Based on training and experience, yes.
Right. Training, experience, judgment.
Right.
And trying then to interpret what you are seeing or may be seeing.
That's true.
There is a subjective quality to this in the end.
The subjectivity of the examination of bloodstains is only based upon your experience and training.
One has to start with examining bloodstains somewhere. You described a 40-hour course required.
Right.
So if, for example, I were to enrol in a 40-hour course in bloodstain analysis, that might be one full week out of my life.
Yes.
8 hours of classroom time for 5 days.
Correct.
And after that, I conceivably could be accredited as a bloodstain examiner.
Yes, that's true.
But you wouldn't, as someone in a supervisory position at the State Crime Lab, wouldn't necessarily send me out to a crime scene alone to do a bloodstain analysis the following Monday, would you?
That's correct.
You would want me to get some on-the-job experience.
Yes.
Tagging along behind more experienced bloodstain pattern analysts.
Yes.
And that would go on for some period of time before I was flying solo.
Correct.
And if after a year, if I was an apt pupil, I was able to be out on my own examining bloodstain patterns, would that seem about a reasonable sort of progression in, let's say, the Wisconsin State Crime Laboratory?
I suppose that's an adequate amount of time.
Okay, but then if we checked in with me 5 years later and I had been doing bloodstain pattern analysis all 5 years, you would expect me to have more experience at the end of 5 years.
True.
And perhaps then better interpretive skills.
True.
More experience with seeing a wider variety of staining.
Well, yes.
So, we could go on, but it's experience plays a large part in the judgments or interpretations that you ultimately reach.
Correct.
Now, even there, you were very careful on direct examination to use the term consistent with. Did I recall that correctly?
When it comes to the contact stains?
Yes.
And also the path of stains?
Yes, and the patterns that you see.
That's correct.
So, for example, although one of the stains in the cargo area, now on the wheel well, you describe as sort of a classic hair contact or transfer stain.
Yes.
Again, what you are telling us is that's consistent with what you saw was consistent with a hair contact or transfer stain.
That's correct.
When something is consistent with something else, it's a possibility that cannot be excluded.
That's right.
And some of these things, like, for example, a hair transfer stain, you personally have enough experience to say, I'm quite confident that this was bloody hair that left that transfer stain.
Yes.
Other transfer stains, maybe, what's the word I want? More generic, if you will.
That's a good term.
Less classic.
Right.
And what you can say there is, well, that would be consistent with, for example, a bloody finger being swiped across the surface, just to pick an example.
That's a possibility, yes.
But you could not and would not say that it is consistent only with a bloody finger being swiped across
No.
a surface.
I would not.
There are other explanations that also may be consistent with the appearance of such a contact stain.
There can be, yes.
You, in your line of work, avoid assigning probabilities to the one or two or three or more different consistent explanations with the source of a stain.
I don't know that you can establish a probability.
So you don't try.
Correct.
Now,
the only thing I can say is when I use consistent, it's probably more likely that that stain was caused by a certain action.
All right. But again, you can't get into specifics often, whether it's an elbow, whether it's a finger, whether it's whatever.
Correct.
Okay.
I mean, you can exclude certain things. If you're talking about a very small stain, you can see that the pattern goes from left to right and it doesn't get any larger, then you can narrow it down to a smaller item rather than a larger item.
Right. All right. And that's some of this gets to be fairly common sense.
Absolutely.
If it's the sort of stain you have described, this is probably not someone who's had their jugular vein cut.
Correct.
There are, though, you can, sort of rule out some stain patterns and say that a stain pattern you see is inconsistent with something, correct?
You certainly may be able to do that, yes.
You're familiar with something called high-velocity spatter?
Oh, yes, I am.
High-velocity spatter typically would be the spatter you get from a bullet passing through a human being, an animal, something that has blood.
High-velocity impact spatter is consistent with gunshot wounds.
There are also things called low-velocity spatter.
Correct.
And give us the classic example with which that would be consistent.
Passive drop, falling to the surface.
Okay.
Generated only caused, only influenced by gravity. So it would be a drop separating from the end of a finger or impacting the surface. That would be a low velocity stain.
What would you typically describe a stain if you had, let's say, a knife stabbing someone in the back and being taken out and struck into the back over and over again?
Stabbings I have seen between medium to high velocity impact stains caused from a stabbing, and it really has a lot to do with the vigorous stabbing of that victim.
In this Toyota, and I will include the rear cargo area, you saw nothing that you would describe as high velocity spatter?
No, that's correct.
Did you see any medium velocity spatter?
Yes, I would say the stains that were on the rear door, cargo door, surface would be defined as medium velocity spatter.
Again, from maybe a body in motion and blood sort of splaying off the body?
That's correct.
All right. As to the stains against the passenger side wheel well in the cargo compartment?
Okay.
Which included the classic hair transfer that you described?
Yes.
That's probably the stain area where you have the greatest confidence about the probable source of the pattern.
As far as the pattern, I would have a better or a good feel for the source of that stain, yes.
Right. Even there, you are not able to venture an opinion on whether the person who left that with the bloody hair was alive or dead at the time.
No, I could not determine whether or not that person was alive or dead.
Are you actually part of the field response team, or do you just coordinate it? I wasn't clear at the beginning of your testimony yesterday.
No, I'm the coordinator, but I also serve as a team leader as well.
So you will go out into the field and respond if asked?
Yes, that's true.
You were not asked to respond to the Avery auto salvage property?
No, I was not on call at that particular time.
Never went to that property yourself?
No, I did not.
Your first work on this case was on Monday, November 7th?
Yes.
Right in the garage at the crime lab in Madison?
That's correct.
Had you been asked, you would have come to the Avery salvage scene?
I don't know that I would have been allowed to, no.
Because you weren't on call then?
Correct.
All right. But as you come here now, you have no way of knowing, for example, where on the Avery property this Toyota supposedly first was seen?
No clue.
No clue how far away from where the Toyota was supposed to have been any bone fragments may have been found?
No, I do not.
You do know enough to say that once those battery cables were disconnected, the key to the Toyota wouldn't have done you any good in starting the car.
Well, that's true.
Unless you reconnected the battery cables.
Correct.
That's all I have, thank you.
You're welcome.
Mr. Gann, any redirect?
Just one moment, Your Honor. No questions, Your Honor.
All right. The witness is excused, and the state may call its next witness.
State would call BLAINE Dassey to the stand, Judge.
Please raise your right hand. Please be seated. Please state your name and spell your last name for the record.
BLAINE Dassey. Dassey.
BLAINE, you don't have to be quite as close to the microphone as you are, so just sit back and relax and testify from there. How old are you, BLAINE?
18.
Do you go to school?
Yes.
Could you tell the jury where you go to school, please?
Mishcot High.
Have you gone to Mishcot High School your entire high school career?
No.
Last year, that is, in 2005, can you tell the jury what school you went to then?
Reedsville.
BLAINE, I'm going to direct your attention to October 31st. Halloween of 2005. Ask if you remember that day.
Yes.
Can you tell the jury where you were living then?
Avery Road.
Okay. You don't have to give me the exact address, but who did you live with there?
My mom and stepdad.
Okay. Now, this Avery Road property, can you kind of describe this property for us?
It's a salvage yard.
All right. I'm going to put on the screen to help you an exhibit that's already been received. It's called Exhibit number 25. When you look at that exhibit, Blaine, does that help you? Do you recognize that exhibit?
Yes.
Tell the jury what that is, please.
That's a salvage yard.
And is that the salvage yard that you lived at on October 31st of 2005?
Yes.
All right. Now, Blaine, do you recognize when you look at that picture? And I know that it's from an airplane, but do you recognize what house you live in?
Yes.
I'm going to give you something called a laser pointer. Have you ever held one of these before?
Yeah.
Just push that button right there, okay?
Okay.
Blaine, I want you to take the laser pointer and I want you to circle or point on the exhibit for the jury what your house is. If you can tell us.
Right there.
All right. And you are pointing to a property. And I think it is uncontested that that's the Barb Yonder trailer. Is that right?
Yes.
All right. Now, Blaine, on the 31st of October, did you go to school that day?
Yes.
And could you tell the jury how you get to and how you get home from school?
The bus.
What kind of bus is this?
School bus.
And looking again at exhibit number 25, can you tell me where the school bus picks you up?
At the end of the road, right here.
You are pointing to an intersection or the end of what would be Avery Road, just up near the office building and your grandparents' trailer. Is that right?
Yes.
In the afternoon, after school is over, how do you get home?
The school bus.
And can you tell me where the school bus drops you off, please?
At the intersection, at the end of the road, by my grandma's house, right there.
Same place?
Mm-hmm.
You have to say yes or no.
Yes.
Now, your trailer is a little bit west or a little bit further down from that intersection. Do you know why the bus picks you up and drops you off near your grandma's trailer?
I'm not sure.
They just do?
Yeah.
Blaine, how do you get to and from the bus from your house?
I walk down the road.
Okay. Now, back in October of 2005, was there somebody else in your house who also went to school with you?
Yeah.
Who was that?
Brandon.
And who's Brendan?
My brother.
At Michigan School, Blaine, do you know about what time school lets out?
3:05.
And after school lets out. And I'm going to specifically ask you about October 31st of 2005. Do you remember what time you came home that day?
3:40.
3:40? That's 20 to 4 in the afternoon. Is that right?
Yup.
You have to answer out loud.
Yes.
Do you remember coming home that day, Blaine?
Yes.
And could you tell the jury how you got home that day?
The school bus.
And did anybody come home on the school bus with you?
Yes. Brandon.
After you and Brendan got home at about 3:40, can you tell the jury what you did, please?
We walked down the road.
And why don't you use your laser pointer again and tell the jury, when you walked down the road, where did you walk?
Down here, right there.
Okay. Just so the record is clear, you are pointing that you are walking in what would be a westerly direction from where the bus dropped you off down to your trailer. Is that right, Blaine?
Yes.
Blaine, as you were, let me just stop. Let me go back and ask a couple of follow-up questions first. First of all, is there anybody else, any other people that live on this property or that did at the end of October of 2005?
No.
There's nobody else that lived on this property?
Oh, yeah.
Are you a little nervous this morning?
Yeah, I am.
That's fine. Tell me who lived on this property? Who else, other than you, lived on this property at that time?
On our property?
Well, anywhere on the Avery property itself. Anywhere on the salvage yard.
Me, my brother, Bobbie, Brian, Brendan.
Let me just stop you right there, Bobbie and Brian and Brendan. Who are they?
My brothers.
And are any of them older than you or any of them younger than you?
Yeah, Bobbie and Brian are older. Brendan is younger.
Okay, and at that time, you know the day I'm talking about, don't you?
Yes.
At that time, you said that Brendan went to school?
Yes.
Do you know what Bobbie did at that time?
No.
Do you know if he was working or if he was going to school or something like that?
I'm not sure.
How about your older brother, Brian? Do you know what he was doing at that time?
No.
Okay. Did anybody else, and in that trailer that you pointed to, you talked about your mom. What's her name?
Barbianda.
Barbianda?
TADYCH now.
I'm going to show you an exhibit. It's a photograph. It's number 354. That's in front of you right now. Can you tell us what that is, please?
That's my mom.
First of all, is that a photograph?
Yes.
And who's it a photograph of?
Barbianda or TADYCH.
I'm going to let the jury look at that picture.
What's the exhibit number?
354. If you want to look on the back of that exhibit, you can see the number on it. Why don't you do that? Do you see that? That's exhibit 354.
Yup.
All right. And the picture on the big screen, is that a picture of your mom, Barb?
Yes.
Now, you were starting to tell us that there were other people who lived at the Avery salvage property at that time.
Yes.
Who else lived there then?
My grandpa and my grandma.
Okay, let's talk about them. Do you know their names?
Yes.
What are their names?
Alan Avery and Dolores Avery.
The exhibit on your right is exhibit 350. 350. Can you tell the jury who that is, please?
That's my grandpa, Alan Avery.
I'm going to show the jury a larger picture of that. That's your grandpa, Alan, is that right?
Yes.
And who lives with Alan?
Dolores.
And who's Dolores?
That's my grandma.
And exhibit 351, that's next to you. Do you see her picture too?
Yes.
And I'm going to show you exhibit 351. Is that a picture of your grandma?
Yes.
Now, Blaine, before we finish the description of your family, do you have any uncles?
Yes.
And who are your uncles?
Earl Avery, Chuck Avery, Stephen Avery.
I'm going to first hand you a picture that's exhibit 353. You mentioned your Uncle Earl. Is that a picture of your Uncle Earl?
Yes.
And I'm showing the jury that big picture. Is that the picture in front of you?
Yes.
Okay.
Your Honour, I have no objections to the photos of the other family members, but as Stephen Avery is sitting right here, I don't know if we need a photograph of him.
Mr. Kratz.
I need a photo of him for later in the trial, Judge, and so this is the best witness to identify that photo.
All right, I will allow it.
Thank you, Judge. Who's the next picture that you have in front of you?
Chucky.
Chucky. Who's Chucky?
He's my uncle.
And that is exhibit number 352, is that right?
Yes.
I'm showing the jury, and is that a picture of your Uncle Chuck?
Yes.
The last picture in front of you is exhibit number 349. Tell us what that is, please.
That's Stephen Avery.
Now that the jury sees that picture, is that your Uncle Steve?
Yes.
That's also the person, as Mr. Strang pointed out, that is sitting at counsel table, who is sitting in the courtroom today. Is that right?
Yes.
Now, Blaine, you talked about getting home at about 3:40 p.m. Do you get home at the same time every day?
Yes.
That day, that is Halloween of 2005, did you have some plans that night?
Yes.
Could you tell the jury what your plans were that night?
My plans were to go trick-or-treating with my friend.
And who is your friend?
Jason Crisco.
Jason. Did you go trick-or-treating with your friend Jason that night?
Yes.
And do you remember, after you got home sometime after 3:40 p.m., do you remember what time you left the house to go trick-or-treating?
Yes.
What time was that?
About 2:25, 5:30.
5:25 p.m.?
Yes.
How did you leave the house, or did you leave the property? Do you remember?
I walked up the road.
Did somebody pick you up?
Yes.
Who was that?
Carmen Wench.
Who is that?
She's my friend's mom.
Okay. And did you go trick-or-treating that night?
Yes.
And so from 5:25 p.m. until some other time, were you gone? That is, were you off the property?
Yes.
Do you remember what time you got home that night?
11.
I'm sorry?
11.
11 p.m.?
Yes.
Let me back up a little bit. And I apologize for kind of jumping around, but you talked about your Uncle Steve. Do you know if he lives on that property as well?
Yes.
Can you tell me on October 31st, that is, on Halloween of 2005, where he lived?
He lived in that trailer house.
How close to your house did he live?
Like right next to us.
All right. I will give you a picture that's going to help, I think. You already looked at this. It's exhibit number 25. Can you show us again where you live? Show us your trailer.
Right there.
And the laser pointer is pointing at the yonder trailer. And where does your Uncle Steve live?
Right there.
Be the trailer that would be directly to the west of you. Is that right?
Yes.
Now, on the 31st of October, as you were approaching your house, as you got off the bus, and you said you were walking down towards your house, did you see anything as you were walking towards your house?
Yes.
Can you tell the jury what you saw, please?
I seen Stephen Avery bring a plastic bag and put it in a burning barrel.
What burn barrel are you talking about?
The burn barrel.
Whose burn barrel?
Stephen's.
I'm going to show you what's been admitted in evidence as exhibit number 114, which is a computer drawing. It's a view that, or an angle that might help you. Do you think this will help you explain to the jury what you saw?
Yes.
Okay. As you are walking towards your house, use the laser pointer. Tell the jury what you saw, please.
Okay. I saw Stephen walking this way through the plastic bag into there and burn the burn barrel.
Okay. Did you see what kind of plastic bag he threw into the burning barrel?
No.
Did you see how big the bag was?
No.
Did you see what was going on inside the burning barrel? In other words, did you see that it was burning in there?
Yes.
Tell the jury what you saw about it, what it was burning. Describe that for them.
There was smoke and flames coming out of the burning barrel.
About what time was this that you saw that?
About 3:46, 7.
Okay. It was right after you got off the bus, is that right?
Yes.
Now, when your Uncle Steve put a bag or put something into that burning barrel that was actively burning at the time, did you have any conversation with him?
No.
Now, I'm going to have you look at this particular drawing or this particular exhibit, 114. Did you see anything else as you were at about 3:45 walking towards your house?
No.
About what time do you think that you got into your house?
Roughly 3:50.
Okay, from 3:50 until you left to go trick or treating, sometime a little after 5. Can you tell the jury what you did that day?
I was on the computer.
Did you leave your trailer at all that day?
No.
I mean, until you went trick or treating.
No.
Do you remember who else was home that day?
Yes.
Who is that?
Brandon.
Were you doing anything with Brendan that afternoon?
No.
Do you know what Brendan was doing while you were home between 10 to 4 and a little after 5 o'clock that day?
Yes. He was playing video games.
Okay. So at least until 5, Brendan was still at home, is that right?
Yes.
Now, when you saw your Uncle Steve burning in his burning barrel, did you see what kind of smoke was coming out of there? Or did you know what he was burning in his burning barrel?
No.
All right. You told this jury that you went trick or treating with your friend and his mom picked you up. Is that right?
Yes.
How did you get home from your mom's that day?
His mom.
How did you get home from your friend's house that day?
Oh, Carmen drove me.
Carmen?
Yeah.
Is that your friend's mom still?
Yes.
And can you remind us again about what time you got home?
About 11.
Okay. Now, at 11 o'clock, when you got home, Blaine, do you remember walking to your house?
Yes.
And when you walked to your house, did you see anything over by Uncle Steve's house?
Yes.
Tell the jury what you saw at your Uncle Steve's house at about 11 o'clock that night.
I seen Steve and Avery sitting there watching the fire.
Watching what?
Watching the fire, the bonfire.
There was a bonfire at your Uncle Steve's?
Yes.
Can you tell the jury where that bonfire was, please?
Behind the garage.
Why don't you look at Exhibit 114? Can you point on Exhibit 114 where you saw that fire that night?
Right there.
We'll have the record reflect, Judge, that the that the witness is pointing directly to the south or just behind the garage area of the diagram in Exhibit 114.
The record will so reflect.
Blaine, tell the jury how big that fire was.
It was about 4 to 5 feet.
What was 4 or 5 feet?
The flames.
So 5-foot flames you could see at 11 o'clock at night. Is that right?
Yes.
Now, How did you know that it was your Uncle Steve out there? Did you see him?
No.
Okay. What did you see out there?
I just seen a person.
Did you know who that person was?
No.
How many people did you see back by that fire?
Just one.
Blaine, the friend that you went with, his name is what, Jason?
Yes'm.
Is that right? His mom's name was Carmen?
Yes'm.
Do you know where she dropped you off that night to come home?
Yes'm.
Where did she drop you off?
At the end of the driveway.
Same place that the bus drops you off?
Yes'm.
When you started walking, or when you walked toward your house that night at about 11 o'clock, when was the first time that you saw these flames, or when you saw what you described as a bonfire behind Steve's garage?
I seen the flames when I left to go trick-or-treating.
Okay, that's 2 different times. Let me just stop you there. I'm talking about when you came home.
Oh.
When? How close were you before you could see the flames?
I don't know.
Let's go back to just before you left, or as you were leaving to go trick or treating. I think you are now going to tell the jury that you saw something else. Is that what you're saying to us?
No, what?
Before you left, or as you left to go trick or treating?
Yeah.
Did you see anything else by your Uncle Steve's?
No.
All right. When was the first time that you saw that fire?
When I came home.
So you didn't see it before you left?
No.
The first time you saw it was at about 11 o'clock. Is that right?
Yes'm.
I just want you to be sure about your testimony. Is that true?
Yes'm.
Okay, good. Now, the flames, or what was creating these 5-foot-high flames, could you see them clearly? I mean, could you see them behind the garage?
Yes.
Could you see anything that was on the fire, or what was in the bonfire?
No.
Do you go back behind your Uncle Steve's garage and see what the bonfire was all about that night?
No.
Blaine, I have a couple other questions. Before testifying in here in court today, before being asked to come to court, do you remember being interviewed by members of police? That is, a law enforcement officer?
Yes'm.
And when you were interviewed by the police, do you remember the police asking you who you saw back by the fire?
Yes'm.
Do you remember what you told the police?
Yes'm.
What did you tell them?
I said I saw Steve and Avery.
Now, you know your Uncle Stephen, is that right?
Yes'm.
Let me ask you, Blaine, are you a little nervous testifying in front of your Uncle Stephen today?
Not really.
All right. The next day, well, let me go back. Just before that night ends, when you got home at 11 o'clock, what did you do?
I went into the house and I fell asleep.
Okay. Do you have a bedroom inside of this house?
Yes'm.
And does anybody stay with you in your bedroom?
Yes'm.
Who's that?
Brandon, my brother.
All right. About what time did you go to bed that night?
At 11.
Okay, so right when you got home.
Yes'm.
When you got home that night at 11 o'clock, do you remember talking to anybody that night?
No.
Do you remember seeing your brother, Brendan, that night?
No.
If Brendan would have been in your bedroom with you, do you think you would have seen him?
Yes'm.
And did you see him in the bedroom?
I don't remember.
Okay, Blaine, I'm going to show you a couple of other pictures here.
Mr. Kratz, can you tell me about how much time you have got left?
5 minutes, Judge.
I think we're going to take a break at this time. Members of the jury, I'm going to remind you not to discuss the case at all during the break, and we will resume in about 15 minutes. Alright, counsel, let's be back at 11.
Thank you, Judge.
Mr. Kratz, you may resume.
BLAINE, when you got home that day on October 31st, on Halloween night, and you walked with your brother to your house, was there anybody else that was with you? Anybody else that walked with you?
No.
I'm going to show you what's been marked for identification. Excuse me, has been received as exhibit number 230. Ask if you recognize that vehicle at all.
Yes'm.
What is that vehicle?
A Suzuki.
A what?
A Suzuki.
A Suzuki. Do you know whose vehicle that is?
My grandpa's, I think that is.
Now, as you look at this picture, do you know where this picture is taken? Do you know where the Suzuki is being stored here?
In Stephen's garage.
All right. Let me ask you something, BLAINE. When you walked home on the 31st of October towards your house, did you see where your Uncle Steve had the Suzuki parked that day?
Could we get a time frame?
I can do that, Judge.
Okay.
At about 3:45 p.m. Did you see where the Suzuki was parked that day?
Yes'm.
Tell the jury where that was, please.
It was on the right side, outside of the garage.
On the outside of the garage?
Yes'm.
I'm going to show you now what's been received as another exhibit to help you. It's exhibit number 98. It's a diagram, kind of a diagram with both residences. Do you see where it says Stephen Avery's residence?
Yes'm.
And the Rhonda Dassey residence, do you see that?
Yes'm.
Well, this diagram, well, first of all, do you recognize these two properties?
Yes'm.
And again, show the jury where it is that you lived.
Right there.
You are pointing to the Dassey Rhonda residence. Is that right?
Yes'm.
And show the jury where Stephen Avery lived at that time.
Right there.
You are pointing to a trailer which is called the Stephen Avery residence. Is that right?
Yes'm.
Now, when you walked home or walked from the bus to your house, you told the jury that you saw the Suzuki parked outside. Is that right?
Yes'm.
Can you point to the diagram and tell the jury where you saw that Suzuki parked that day?
Right there.
And you are pointing to the outside of what would be Stephen Avery's garage, just to the left side, as you look at the diagram. Is that right?
Yes'm.
Did you notice any other things? Any other vehicles out there when you walked home that day?
There was a snowmobile.
Do you know whose snowmobile was outside?
Yes, Stephen's.
Where was the snowmobile parked, if you remember?
In the back of or behind the Suzuki.
Can you show us where that would be, please?
Like right there.
So, near or right next to the Suzuki, on the left side or on the outside of the garage. Is that right?
Yes'm.
Now, I'm just asking you about your observations, BLAINE. I don't know. I don't care who you talk to or what somebody might have said, but just what you saw with your own eyes, okay?
Okay.
Do you remember seeing with your own eyes or remembering your own observations whether or not that Suzuki and that snowmobile were moved somewhere else at some point after the 31st of October?
I'm not sure, no.
Okay. You just remember the 31st, that they were next to the garage. Is that right?
Yes'm.
Let me finally go back to one other diagram that we've been looking at. Exhibit 114 kind of shows us an overview. Can you again point to the burn barrel of Steve Avery, where you saw him burning?
Right there.
Now, can you describe for the jury the smoke or anything else that you saw coming out of that burn barrel when you got home that day?
Asked and answered twice.
I want him to describe, if he can. I want to know if he can describe the color, or if there were flames, or more descriptive of what he saw, Judge. That has not been answered.
It's been asked and answered twice.
I know the question has been answered. If there was something coming out of it, I don't remember if there was a request for a description, so I will allow the question.
If you remember, Blaine, do you remember anything coming out of that burn barrel?
Yeah, white smoke.
All right, Judge, I will move the admission of Exhibits 349 through 354, and I don't have any further questions of Blaine at this time.
Any objection to the exhibits?
Ask the court to reserve on 350. No objection to the others.
All right, the court will receive the others. Reserve ruling on Exhibit 350. Which exhibit was 350?
I'm sorry, 349.
349?
My mistake.
That's a photo of Stephen Avery?
Yes.
All right. The court will allow the rest of them and reserve ruling on 349.
Good morning.
Good morning.
I'm going to call you Mr. Dassey, even though I guess you are 18 now. You turned 18?
Yes.
Since this is a little bit of a formal place, do you mind if I address you as Mr. Dassey?
Yes.
Yes, you do mind?
Oh, no.
All right. Mr. Dassey, you have been approached by the police a number of times, I think, since October 31st, 2005, haven't you?
Yes.
It started probably a week later, on November 7?
Yes.
And on November 11?
Yes.
November 15?
Yes.
And times after that, right?
Yes.
Right up through today, when you talked to Mr. Fassbender during the break.
Yes.
And the police have asked you the same questions over and over and over about October 31st, haven't they?
Yes.
You give them an answer,
Yes.
and if they don't like the answer, they ask you again?
Yes.
Now, at the time, on Halloween 2005, there was nothing really special about that day to you other than it was Halloween, right?
Yes.
I mean, you had plans to go trick-or-treating.
Mm-hmm.
But no big deal about October 31st, 2005, other than that, right?
No.
All right. It was another school day, was a Monday.
Yes.
Every day you get picked up by the bus at about the same time in the morning for school.
Yes.
In fact, probably like any other kid in high school, you know just how long you can stall before going out the door.
Yes.
All right. So you know that the bus comes between 7:08 and 7:13 in the morning, right?
Yes.
All right. And the school, the bell letting you out of school happens at the same time every day.
Yes.
3:05 in the afternoon.
Yes.
The school bus is there.
Yes.
And back in October 2005, you had sort of a nice female bus driver.
Yes.
She was the same bus driver every day.
Yes.
And then every day she takes the same route home, dropping kids off.
Yes.
So you know that, almost to the minute, roughly, when you get off the bus every day, right?
Yes.
You get off the bus every day with Brendan, assuming he's not sick or something.
Yeah.
Now, that's why you were really pretty sure that you got off this bus at about 3:40, something like that?
Yes.
On Halloween 2005.
Yes.
You and Brendan walked down the road together and you both go into your house?
Yes.
You remember because you were asked just a week later that when you walked in, Bobbie was home.
Yes.
Bobbie was sleeping.
Yes.
Bobbie was not out deer hunting.
Yes.
You and Brendan woke Bobbie up?
Yes.
Do you remember doing that?
Yeah.
And then you kind of hung out and you were on the computer until it was time to go trick-or-treating.
Yes.
Brendan was there.
Yes.
He stayed in the house playing video games.
Yes.
The whole time you were there working on the computer, he was playing video games?
Yeah.
You guys have the computer and the video games in the same room?
Yes.
Bobbie at some point left, or do you remember?
I'm not sure. Don't remember.
Okay, but he wasn't out deer hunting. He was in bed sleeping when you got home.
Yes.
Now, you then go off trick-or-treating at, you said 5:25 or 5:30. You thought something like that.
Yes.
But before then, Brendan hasn't left to go get mail for anybody.
No.
You go trick-or-treating, Brendan does not go with you.
No.
So, but when you went trick-or-treating, 5:25, 5:30, whatever it was, it's getting dark?
Yes.
Or dark already?
Yes.
Okay. You are going into Two Rivers, I think.
Yes.
I'm pronouncing that wrong, I know. It's more like Two Rivers.
Two Rivers.
All right. And so you were walking all the way up the driveway to where Carmen is going to pick you up, where the bus turns round.
Yes.
Now, whether it was when you were walking down that driveway from the bus or when you are walking back up to get in the car with Carmen and go trick-or-treating, did you hear any young woman's voice screaming for her life?
No.
Do you hear any gunshots?
No.
If you had heard gunshots or someone screaming for their life, that's something you would remember.
Yes.
All right. And one thing that the police asked you over and over, if you did remember, is whether you saw a fire that day.
Yes.
Do you remember that?
Yes.
They asked you that the first time they talked to you on November 7th, didn't they?
Yes.
Which was the next Monday, right?
Yes.
And you told them there was no fire, you didn't see a fire. That's what you told them on November 7th, isn't it?
No.
Well,
I will need to be heard outside the presence of the jury, Judge.
All right, members of the jury, we'll take a short break at this time.
we also should excuse the witness.
You may be seated, and the witness will be excused out in the hallway. Mr. Kratz?
This is at least the second time, and probably more than that a witness in this case is going to be impeached with somebody else's exhibit. That is, to be shown a police report or an exhibit from somebody other than the witness themselves, other than the declarant, and that is hearsay. If the attempt here is to refresh recollection, then you can do that with the witness's own statement. If the attempt is to impeach the witness, then you can ask, did you tell Investigator Fassbender or whoever such and such? If they say no, then the procedure is to call Investigator Fassbender to impeach with a prior inconsistent statement. But using this procedure to show a witness a police report, a document that this witness did not author and presumably has no ability to determine its reliability or authenticity, I think is improper. I have made this objection before in this trial, Judge, and I raise it again because it appears that the same procedure is being attempted at this time.
Mr. Strang?
Well, first of all, if I understand the objection, the document I'm intending to show him is an interview of BLAINE Dassey. It is not an interview of someone else, and I intend to show it to him and ask him if that refreshes his recollection. If it does not refresh his recollection about what he said, then I intend to ask him, and I can read it verbatim. did you tell, 2 agents of the Division of Criminal Investigation on November 7 that there was not any bonfire? If he denies it and, if at first doesn't have this recollection refreshed, and then if he denies saying it, yes, eventually I suppose we would have to perfect the impeachment by calling one of the reporting agents or one of the agents present. But there is nothing in the world wrong with showing this to him to refresh his recollection or ask him to tell me whether the agents got it wrong.
Mr. Kratz?
I disagree, Judge. I think he can be shown his statement. If there's a written statement that this witness generated, perfectly reasonable to show him his own statement. That happened with Miss Zipperer. Show her her statement. Does that refresh your recollection? She can say yes or no. But to show a police report from a collateral source, from a third party, and asking if this refreshes a person's recollection when they didn't create it is absolutely improper and is hearsay.
90612 allows the use of anything that may refresh recollection, and certainly a report of a law enforcement interview with the very person falls well within the term of anything.
Well, doesn't the first step have to be to ask the witness if looking at the document would refresh the witness' recollection?
I can do that, sure.
And what if he says no?
Well, then I will. Then I will ask him if he said it.
Do we know whether or not the witness has ever seen this document before?
I have no idea. Now, if Mr. Kratz is suggesting that there's a handwritten statement from BLAINE Dassey, then I should look again.
No, I said if there was, he could use it, as in Mrs. Zipperer's refreshing recollection.
So there's not a statement of the witness?
That's correct. No handwritten statement.
What is the state's authority for the proposition that a witness' recollection can only be refreshed by looking at a statement of the witness, him or herself?
Well, 90612 starts with, if a witness uses a writing to refresh the memory for the purpose of testifying, an adverse party is entitled to have it produced at the hearing. That's not what we're talking about here, Judge. This witness hasn't said there's some writing that can refresh my recollection. There's some business records, there's some document that I know of that exists in the world that can refresh my recollection. That's 90612.
Maybe I'm missing something here, but I'm not sure the parties disagree. Mr. Strang asked the witness if looking at a police report, a police interview with the witness would refresh the witness' recollection. The witness may say yes or no. It's possible the witness may remember that somebody was taking notes, and maybe looking at the document would refresh the recollection, in which case the document doesn't get introduced as evidence, but the witness can look at it. If the witness says no, I don't think that would refresh my recollection, then Mr. Strang doesn't get to show it to the witness and moves on to the next question.
Well, then we go to 90613 and I ask him. He gets an opportunity to admit or deny that he made the statement, and then impeachment will be perfected by calling someone else who was present or heard it.
You mean you would call Mr. Fassbender or someone else later?
It wasn't Mr. Fassbender, but...
Whoever?
Right. Someone who was present, one of the 2 authors of the report, hopefully.
All right. Well, if there's an objection to that, it's an objection for a later time. I believe, all right. It seems to me that Mr. Strang can ask the witness whether or not reviewing a report, if he knows of its existence, would refresh his recollection. If it does, the witness can look at it. Doesn't mean the report becomes evidence. If not, then Mr. Strang moves on to the next question. Let's bring the jurors back in. You may be seated. Mr. Strang, you may proceed.
Thank you. Let's go back to where we were when we left off. Do you suppose that if you looked at a police report from your November 7th, that first interview with some agents, that it might help you remember today what you told them then?
Yes.
I have marked this with an exhibit number for you. It's exhibit 355. It's a DCI report. The only page numbers here are the ones that I have added, but I'm going to show you the 6th page.
Mr. Strang, I'm going to ask you that you show Mr. Kratz which page you are going to be looking at.
Sure, absolutely. All the pages are unnumbered. It's the 6th page of the report, and specifically, Counsel, I'm going to be inviting him to look at the 2nd paragraph on page 6. So now I will show it to you. You can look at anything you want in here, but I thought that that 2nd paragraph right there might help refresh your recollection. Now, don't read it out loud, just read it to yourself and see if that helps you remember. Is that any help?
Yeah.
Okay. Now, on Monday, November 7, 2005, when the officers asked you...
Just a second, Mr. Strang, can you pick up the document?
I would be happy to, sure. So, Monday, November 7, Monday after Halloween, when the officers asked you if there was any bonfires last week, you told them there was not. Is that right?
Yeah.
And you said you would know if there was a bonfire because you always liked to have bonfires.
Yes.
Steve would have bonfires back in that burn area occasionally?
No.
Didn't Steve have fires in his burn area once in a while?
Which burn area?
Behind the garage that you were telling Mr. Kratz about?
No.
Never any bonfires back there, no?
No.
Just this one item?
Yes.
Didn't Steve invite you later that week to bring some friends over for a bonfire?
Yes.
But that never happened?
No.
Your friends didn't want to come?
No.
But Steve, when I say Steve, your uncle Steve, made the invitation to you to bring other kids, other high school students over, right?
Yes.
Invitation that, had it been accepted, would have had a bunch of kids standing around that burn area.
Yes.
Maybe poking around in the fire.
Yes.
Or watching it for some hours.
Yes.
And you didn't tell the police on November 7 anything about any fire in this burn barrel either, did you?
Yes.
Yes, you did tell them about a fire in the burn barrel?
Yes.
Do you think that would be in the report, or maybe they forgot that?
I don't know.
Okay. You do remember eventually telling the police about a fire in the burn barrel, right?
Yes.
What was that the 2nd or 3rd time they asked you about it?
Yes.
Not the 1st time they asked you?
No.
Now, sometimes when Steve has a fire, he burns wood. You know that?
Yes.
Sometimes he burns tyres.
Yes.
And you guys all have burn barrels out by your houses.
Yes.
When you were interviewed on November 7, 2005, you told the police that you actually hadn't seen Steve, your uncle Steve, at all when you walked down the lane from the school bus to your house, didn't you?
No.
We'll go back to Exhibit 355 again. And now I'm going to be going to page 4, and I will show you that again. Do you think that might refresh your recollection again about whether you were asked if you saw Steve at all when you were walking home from school and what you told the police on November 7?
Yes.
Now, Mr. Dassey, around page 4 of that same exhibit, 355, look at anything you like, but again, the 2nd paragraph on the page is the one that I thought might help refresh your recollection. Does that help?
Yes.
I will take it back from you. No cheat sheets. Now that you have had a chance to refresh your recollection about what you told the police, it's true that they had asked you if anything happened between 3:30 and 5 on that Halloween afternoon, and you said that nothing happened, right?
Yes.
And they asked you specifically if you saw Steve during that time period, and you said that you did not.
Yes.
And you also were asked if Steve had asked you to help move the Suzuki or the snowmobile, and you said no, he hadn't asked you to help move the Suzuki or the snowmobile, right?
Yes.
And you told them that was something you would remember if Steve had asked you.
Yes.
So, same thing happened again on Friday, November 11. Same sort of questions from the police, weren't there?
Yes.
And again, you told them that you did not see a fire in a burn barrel or Steve with a white plastic bag. That's what you told the police that Friday, November 11, right?
Yes.
And finally then, on the 15th of November, they came back and they asked you again. And that's when you said you saw Steve putting a white plastic bag in the burn barrel. Is that right?
Yes.
Now, if you saw Steve put a white plastic bag in his burn barrel on Halloween, as you told the police then on November 15, that's what, 15, 16 days later?
Yes.
Something memorable about seeing your uncle put trash out in the burn barrel?
Yeah.
Really?
Yes.
He doesn't put trash in the burn barrel?
Yes, he does.
Okay, no special reason you would have been paying attention to that on Halloween, is there?
No.
No. And when you were asked by Mr. Kratz, you said, yeah, I think that was at 3:46 or 3:47 p.m. Do you remember saying that?
Yes.
No special reason you would have remembered today whether Mr. Avery put a white bag of trash in his burn barrel at 3:46 or 3:47 p.m., is there?
No.
Now, this Suzuki, you were not asked to help move the Suzuki or the snowmobile around.
No.
No. And that Suzuki actually had been outside Steve's garage for a week or two before Halloween, right?
Yes.
Do you remember, Mr. Dassey, being interviewed by the police, I don't know, I guess the third time, that November 15 interview? Do you remember that interview taking place in a restaurant?
Yes.
The Cedar Ridge restaurant?
Yes.
Over in Maribel, near you?
Yes.
Okay. Was your mum there for that?
Yes.
Just you and your mum?
Yup.
And then a couple of officers or agents?
Yes.
And did you guys sit across the table from the agents in the restaurant?
Yes.
Did there come a time in that discussion between you and your mum and the agents when the agents sort of got in your face a little bit?
Yes.
What were they doing to get in your face?
They were arguing.
They were arguing?
Yes.
They raised their voices?
Yes.
They got angry?
Yes.
They accused you guys of not accepting that Steve was guilty, didn't they?
Yes.
They accused you of embarrassing yourselves by believing in your uncle, didn't they?
Yes.
They tried to convince you that Stephen Avery was guilty, didn't they?
Yes.
And they got loud about it at the restaurant?
Yes.
And then they stomped off and left you there when you wouldn't turn on your uncle, didn't they?
Yes.
And that was back in November 15 of 2005.
Yes.
That's all I have.
Blaine, at that November 15 meeting, before they stomped off, did they tell you to tell the truth?
Yes.
Were they upset at you because they thought that you weren't being honest with them and telling the truth?
No.
During that day, during the 15th, as Mr. Strang has mentioned, do you recall telling the police officers that, in fact, you did see your Uncle Stephen burning in his burn barrel, putting his white plastic bag in there?
Yes.
Do you recall that same interview telling these same officers that you saw a fire, a bonfire, the night of the 31st of October?
Yes.
And is that the time that you identified that it was your Uncle Stephen and Stephen alone that you saw standing by the fire?
Yes.
How old were you at the time, Blaine?
17.
And as a 17-year-old young boy, was there a lot going on in your household at the time?
Yes.
Was there a lot of pressure being put on you by family members on what to say and what not to say?
No.
Was there any pressure Or did you have any concerns about your Uncle Stephen at that time?
No.
Do you recall telling investigators that you were scared of your Uncle Stephen? That's the word you used, scared. Do you remember that?
Yes'm.
Yes?
Yes'm.
What were you scared about with your Uncle Stephen? Why were you afraid to tell the truth about your Uncle Stephen?
Object to the state's testimony, argumentative.
I can rephrase, Judge. What were you scared about with your Uncle Stephen?
Because he used to boss us around.
Who's us?
Me and my brothers.
Were you afraid what your Uncle Stephen might do to you if you told the statement or testified against him?
No.
You were just generally scared of him?
Yes'm.
All right, Blaine. That's all I have for you. Thank you, Judge.
Well, Mr. Dassey, when you finally told the police on November 15 that there was this bonfire going and you saw it when you came home from trick-or-treating?
Yes'm.
As Mr. Kratz said you saw only one person there.
Yes'm.
You went in your house.
Yes'm.
And you told them, too, that you remembered seeing Brendan and that you talked with Brendan about trick-or-treating in your house when you got home, didn't you?
Yes'm.
And then you went to bed?
Yes'm.
That's all I have.
All right. The witness is excused.
State will call FABIAN to the stand, Your Honor.
Raise your right hand. Please be seated. Please state your name and spell your last name for the record.
Robert Fabian, F-A-B-I-A-N.
Mr. FABIAN, do you know the defendant, Stephen Avery?
Yes, I do.
He's the gentleman seated in the courtroom next to his lawyers, is that right?
That's correct.
On October 31st of 2005, do you remember seeing Mr. Avery?
Yes, I do.
Now, do you know any of the other members of the Avery family?
Yes, I do.
And is there one of the Averys that you know better than the others?
Probably Earl.
Who is Earl Avery?
Would be Stephen's brother.
On October 31st of 2005, do you recall being with Earl Avery that day?
Yes, I do.
Now, are Earl and you friends?
Yes.
On the 31st of October, that would be Halloween. Is that right?
That's correct.
On that date, were you and Earl doing something together?
Yes, we went rabbit hunting.
And where did you go rabbit hunting?
In the junkyard.
By the junkyard, are you referring to the Avery Salvage Yard?
That's correct.
And was there a mode of transportation or a way that you were getting around the junkyard while you and Earl were rabbit hunting?
Yes, we were using a golf cart.
Do you know whose golf cart that was?
I believe Mrs. Avery.
Do you mean Dolores?
Yes, correct.
Earl's mom?
Yes.
When did you begin rabbit hunting that day? Do you remember?
I believe I got there. It was about 10 to 5, quarter to 5, something like that.
All right. Do you know about what time it gets dark or got dark around the 31st of October?
I do remember when I got home, it was like quarter to 6.
Was it getting dark or was it dark by about quarter to 6?
I believe it was, yes.
Just before getting dark or just before your rabbit hunt was completed, did you find your way up towards Stephen Avery's trailer?
Yes, we did.
I'm going to show you an exhibit which has been received. It's number 114. It's a computer animation, a drawing, but will this exhibit help you describe or explain the rest of your testimony?
I believe so.
Do you recognize that general area?
Yes, I do.
And what is that area, generally?
Stephen Avery's residence.
All right. Now, do you see both a burn barrel there, a garage, a trailer, and a reddish maroon either Voyager or Caravan?
Yes, I do.
All right. Now, on the 31st, that is, on the October 31st of '05, did that area generally look like that?
Somewhat, yes.
Were there some differences on the 31st of October?
Yes, I believe there was a snowmobile trail hooked up to the truck, and I don't believe the garage door were open, and I don't remember the van sitting there.
All right. Let's talk about each of those things individually. First of all, let me talk about the garage door itself. About what time, if you can place, as best as you can recall, about what time were you in that general vicinity?
I would say maybe 20 after 5.
This is p.m.?
Correct.
And at 5:20 p.m., did you have occasion to look at Mr. Avery's garage door?
I didn't specifically look at it, but it was closed, I believe, at the time.
All right. With the garage door being closed, were you able to see what was in the garage door at that time?
No.
There's some other things on this diagram, specifically the burn barrel. Do you remember that barrel on the 31st of October?
Yes, I do.
Tell the jury what you remember about that burn barrel at about 5:20 p.m. on the 31st of October.
When me and Earl had pulled up on the golf cart, we had stopped in between the house and the garage, and the smoke from the burn barrel was blowing right in my face. So I told Earl to move ahead.
You have got a laser pointer right in front of you. I don't know if you know how to work that thing. There's a little button on it. If you can point at the exhibit, first of all, point out the burn barrel. What are you talking about?
Right there.
All right. You and Earl were both on the golf cart?
That's correct.
Where were you parked at first with the golf cart?
When we had pulled up, we had come from this direction, and we had pulled up in here, somewhere up in here.
You are pointing to an area which is still on what would be the driveway area, but just south of or southish of the burn barrel. Is that an accurate description?
That is correct.
From the east to the west, I think the witness was showing.
Yes, I'm sorry. You were pointing from the east to the west?
Yes.
Towards Stephen's trailer?
Correct.
Did you actually stop in the golf cart? Did the golf cart come to a complete stop?
Yes, we had stopped, and that's when the smoke was blowing in my face.
Okay, let's talk about the smoke and where was it coming from?
It was coming from the burn barrel.
Can you show us again where that was coming from?
Over there. It was coming from there and coming this way.
All right. Describe for the jury as best that you can remember, if you can remember, at about 5:20 p.m. What was the smoke like?
It was kind of a heavier smoke, and it smelled like plastic. It didn't smell like regular garbage.
Well, let's talk about that a little bit. Have you smelled plastic or plastic components being burned before?
As a kid growing up in the country, yes, I burned a lot of garbage.
All right. Is it your testimony that burning plastic smells different than just regular burning garbage?
That's correct.
And what did you smell that day?
It was plastic.
Now, did you ever get out of the golf cart and look in the burn barrel and see what kind of plastic things were burning in there?
No, I did not.
When you stopped the golf cart up towards Stephen's trailer, did you actually have occasion to see Stephen Avery?
Yes, we did.
And can you describe where you saw him or where he was coming from?
The first we had seen him is when we were pulling up here on the golf cart. We were not stopped yet. And he had come out of the door of the house and come down the steps and was headed towards the garage.
All right. Did he make it all the way to the garage?
No, he did not.
What happened then?
I believe Earl asked him what he was doing, and he came walking over to the golf cart.
Did you have a conversation with him at that time?
Yes.
All right. How long were you in the golf cart? How long was the smoke coming toward you at the time?
The smoke was only bothering me for a few seconds or so, and I had told Earl to pull ahead, made him pull ahead so it wouldn't bother me. So that's when he had pulled ahead.
Mr. Fabian, could you describe, I know you said it was 20 after 5, but could you describe the lighting conditions? What time of day was it? How close was it getting towards dusk?
It was getting towards dark, getting relatively hard to kind of see already.
All right. Good enough. That's all I have for this witness, Judge. Thank you.
I think at this point we'll take a lunch break and start back with cross-examination after lunch. We will resume at 1. Members of the jury, I will remind you again not to discuss the case in any fashion over the lunch break. You are excused at this time. You may be seated. Counsel, I just want to check the agenda for this afternoon. Mr. Kratz?
Yes?
Who's on your witness list for this afternoon?
After Mr. TADYCH, Judge, we do have the 2 telephone record custodians. Excuse me. We also have available 2 law enforcement officials who search what we now know as the burn area. So we can proceed with any of those because the records custodians are relatively short and they have come here today. I would like to put in those records and their testimony. And so if I had a preference in order, I would call Mr. TADYCH, the 2 records custodians, and then we would move on to the burn search area.
Mr. Strang?
Probably we would be better off discussing scheduling off the record. Would that make sense?
All right, we'll go off the record at this time. Mr. Strang, you may begin your cross-examination of the witness.
The following afternoon, you get to the Avery salvage property to see your friend Earl at about 4:45, 4:50?
That's correct.
4:45, 10:05, something like that.
Yeah.
The 2 of you are planning in advance to do some rabbit hunting.
I think I showed up unannounced.
You showed up with a rifle, though, to do some hunting?
Correct.
Earl had a rifle to do some hunting?
I believe he was working at the time when I arrived.
I'm sorry?
He was working at the time I arrived.
Mm-hmm.
Which would have been at closing time.
But he also participated in the rabbit hunt?
Correct.
That required a rifle?
Yes, I believe.
You weren't snaring rabbits?
No.
Or trying to shoot them with a bow and arrow?
No.
Okay, the 2 of you then do that, and I take it you have to break off rabbit hunting before it's dark out?
Correct.
You have to be able to see the rabbit?
Correct.
The time over at near Stephen Avery's trailer then is as darkness is approaching?
That's correct.
You are nearing the end of your hunt?
That is correct.
It has taken you about 15 minutes to drive from your house to the Avery salvage yard?
Approximately 15.
It will take you about 15 minutes to get back, give or take?
That's correct.
And you think you are back by 5:45?
That's correct.
That is back at your house?
At my house, yes.
What's your rabbit gun?
I have a 22.
Okay, standard sort of small game gun?
Yes.
Did you guys get any rabbits that day?
No, we did not.
The smoke that you smell near the burn barrel, you were in the path of it for a few seconds?
That's correct.
You get out of the path of it?
That's correct.
You know that from living in the country yourself, that burn barrels are for burning garbage, typically.
Yes.
Garbage may include plastic milk cartons?
That's correct.
Plastic cartons from other things from the grocery store?
That's correct.
Maybe a plastic garbage bag itself?
That's correct.
All kinds of plastic items that may be in garbage when you were burning it?
Yes.
You didn't look in the burn barrel?
No, I did not.
You noticed that the burn barrel was already burning, obviously?
Yes.
Didn't see anybody put anything in the burn barrel?
No, I didn't.
Saw at the side that there was, well, let me ask you, you didn't smell a tyre burning?
No.
You know the smell of a burning rubber tyre?
Yes.
Didn't see heavy black smoke coming out?
No.
All right. Didn't see a tyre or a rim assembly lying next to the burn barrel either?
No, not that I recall.
You certainly saw no larger fire going in the burn area?
No, I did not.
Didn't hear any screaming?
No, I did not.
Didn't hear any gunshots coming from that area?
No, I did not.
That's all I have. Thank you.
Any redirect?
Not of this witness, Judge.
Very well. You're excused.
Thank you.
State would call Scott TADYCH to the stand.
Please raise your right hand. Please be seated. Please state your name and spell your last name for the record.
Scott TADYCH. TADICH.
Mr. TADYCH, I'm going to ask you some questions regarding October 2005. Let me first ask you if you remember that particular day. And can you tell the jury how it is that you remember that day? How that day sticks out in your mind?
It was the fire that I remember the most of that day.
You said the fire that you remember most. Can you tell the jury what fire you are talking about?
The fire by Stephen's trailer.
Let's back up just a little bit. Sometime on the 31st, that afternoon of the 31st of October 2005, do you remember what you were doing?
Could
you tell the jury what you did that afternoon, please?
That afternoon or that morning, I was up by my mother. She had surgery. Then I left her and I went to the woods hunting. I went to my trailer and then I went to the woods hunting.
What kind of hunting did you do that day, Mr. TADYCH?
Archery hunting, bow hunting, archery.
About what time was it that you got out into the woods or that you got to your deer hunting stand?
About 3.
On your way to deer hunting, that would be just before 3 p.m. Did you observe anybody on the roadway?
I did.
Could you tell the jury who you saw on the roadway before 3 o'clock that afternoon?
I saw the BOBBIE Dassey on Highway 147.
Which way were you going and which way was Bobbie going, if you recall?
I was going west and he was going east.
Where is it, Mr. TADYCH, that you hunt? Or at least that day. Where was it that you were going hunting?
In Kawani.
Now, at that time, that is on the 31st of October of 2005, did you know anybody who lived on what is known as the Avery salvage property?
I did.
Who did you know on that property?
Everybody that lived there.
Okay. Is there anybody there that you knew better than someone else?
Oh, yes. Barbianda, I guess.
All right, well, who is Barbianda now to you?
My wife.
I suspect you weren't married to anybody else on that property.
Hope not, no.
All right, I'm going to show you what's been marked for and received as exhibit number 98. It's a computer-generated diagram. Do you recognize this area of the Avery salvage property? And will this diagram assist you in describing for the jury what you saw that afternoon and early that evening? Mr. TADYCH, after your hunt was completed, about what time was that?
About 5. 10 after 5 or so. 5. Whenever dark was.
Do you remember if you had gotten anything that day?
No.
At 10 after 5 or sometime after 5 p.m., tell the jury where you went, please.
I I went back to the Yanda's residence, the Dassey residence, to pick up Barb to go back to Green Bay to see my mother.
All right. Do you remember what kind of surgery your mother had that day?
Back surgery, I think.
Barb, at that time, Barb Yanda, what was your relationship with her?
We were friends, I guess. Best friends.
All right. Were you dating at the time?
Yes.
Do you remember about what time you got to Barb Yanda's house to pick her up that night?
Which time? What do you mean? After 5 p.m.?
Well, after you went hunting. Did you stop?
Da, I did.
Was Barb home?
Da.
Do you remember? Did she have work at that time? Was she employed?
Da, she was working.
About what time was it that you got to her house, if you remember?
Between 5 and quarter after 5. 5. Something like that. Around in there.
Sometime around 5:15 then, when you got to her house. By the way, what kind of vehicle were you driving? Do you recall?
A green, not bluish green, but green Ford Ranger.
When you got to her vehicle in the green, not bluish green Ford Ranger, can you tell us where you parked?
When I got to her home?
Yeah. Mr. Fassbender is going to give you a laser pointer to help you describe for the jury where you parked.
Right about there.
And you are pointing, which would be just to the west of a purplish vehicle in what would be a circle driveway. Is that right?
Da.
And that's on exhibit number 98. Mr. TADYCH, when you parked that vehicle there sometime at about 5:15 p.m., did you notice anything or observe anything unusual around that property? If you recall. If not, we'll move on.
I do not recall at the time.
Did you pick up Barb then?
Da, I did.
And where'd you guys go?
Back to Green Bay.
Did you visit your mother in the hospital?
Da.
How long did that visit last? Do you recall?
I was up there until probably, I do not know, 7:30, quarter after 7, 7:30.
Sometime after 7:30 p.m. Then, did you return to the Yonder property?
Da, I did.
And were you still with Barb at the time?
Da, I was.
When you got back to the Yonder property, was it light out or dark out?
It was dark.
At the time. Okay. Mr. TADYCH, I'm going to have to remind you to wait until my questions are done.
Fine.
So that the court reporter can write it all down. Is that okay?
Whatever. Yes, fine.
All right. When you got back, by the way, why did you go back to the Yonder property at that time?
To drop off Barb at her house.
And can you tell the jury why, please?
Drop her off at the house?
Yes.
That's where she lived. I was going home.
Were you going to see her later that night?
Da, I was.
So why did you stop at Barb's house?
To drop her off so she can get her vehicle.
All right. In dropping Barb off so she could get a vehicle, can you tell us where you parked at that time?
Right about. I come in and I parked right about there.
And if you can just use the laser pointer and tell us from which way did you come in?
Here and there, and then I went here and then I came back.
All right. There's a purplish vehicle in front of the residence. Was that purple vehicle in that circle driveway when you got there on the 31st?
I do not remember that.
But you came in from what would be a generally easterly direction. You were generally going west. Is that right?
Da.
Did you park your vehicle?
Just long enough for her to get out of my vehicle.
And who is her?
Barb, my wife.
Did Barb get out of your vehicle?
Of course, if I was dropping her off.
Where did Barb go if you saw her?
She went towards her house.
Towards whose house?
Her house.
All right. At the time that you dropped Barb off, do you know about what time it was?
7:30, 7:45, something like that.
About 7:30 to 7:45 p.m. Did you notice anything unusual around the property at that time?
Da, I did.
Could you tell the jury what you saw at that time, please?
Oh my God, I saw a big fire.
Can you tell the jury where you saw the fire, please?
Right there.
You are pointing to an area just south of the garage, known as the Stephen Avery garage. Is that right?
Da.
Could you describe that fire for us, Mr. TADYCH?
It was such a big fire. It was bigger than normal.
That's got a couple aspects to it. I'm going to go one at a time. First of all, you said that it was a fire. Did you see flames?
Of course I did. I did see flames.
Did you notice if anybody was standing in the area or around the fire? Did you notice somebody back there?
Da, I did.
Do you know the defendant, Stephen Avery?
Of course I do.
And did you see Steve Avery standing next to or near that fire?
Yeah, I did.
Did you see what Stephen Avery was doing at the time?
Standing there, standing by the fire.
All right. Are you able to estimate from your observations how high or how tall the flames were as you were watching there about 7:45?
Oh my God, you have to ask me that quicker. I want to tell you how big it was. It was tall as the garage.
All right, so
8-10 feet. Telling you, I do not know. 10 feet, maybe 10 feet tall. The flames were, it was crazy.
It was a big fire?
It was a big fire.
All right. Did you ever get out of your vehicle at the time?
No, I did not.
Did you ever approach the big fire or approach Mr. Avery at that time?
No, I was afraid. Did not.
Where did you go then, Mr. TADYCH?
I ran as fast as I could back to where I was living at the time. The trailer house on 147.
I'm sorry. Could you tell us what community that was?
Michicot.
About how far away was your trailer from your girlfriend Barb's trailer?
About 2 miles. 2 miles away.
Sometime shortly after you got to your house. That is sometime. By the way, when did you get to your house?
About 7:45.
Okay. Do you know if it was before 8 or...
Before 8, yes, before.
How do you remember that?
Because I wanted to go home and watch a TV show. It was prison break time.
Which show did you want to go watch?
Just told you, prison break.
Started at 8 o'clock?
It did.
Did you get home before the show started?
Yes, of course I did.
Sometime shortly after you got home, Mr. TADYCH, were you joined at your house by anybody?
My wife, Rhonda, TADYCH.
Do you know about what time Barb got to your house?
I do not recall what time she got there, but it was shortly after.
Do you remember that night how long Barb stayed at your house or how long she visited?
A couple hours she was there.
Did she spend the evening or did she leave to go home at some point?
She left and went home. But then another time I remembered she spent the night, so I'm not sure, but I think she left and went home.
Do you have an estimate as you think back as to when she left?
About 10:30, 11 p.m.
That's your best estimate as you sit here today?
Da.
I think that's all I have, Mr. TADYCH. Thank you, sir.
No problem.
Mr. Strang.
Mr. TADYCH, you remember October 31st, 2005, because you skipped work entirely that day.
I did not skip work. I took vacation that day to be with my mother.
That is, you were not at work.
Right, I wasn't at work.
Okay, I didn't mean to suggest it was unexcused, but you did not go to work on October 31st.
No, I did not.
You went to Green Bay to see your mother.
That I did.
You said she had recently had surgery.
That I did say that.
Other than your mother, who would have seen you on October 31st before you say Bobbie Dassey saw you as the two of you drive past one another on Highway 147?
Nobody. Just I went from the hospital to my trailer.
Now, you got home from the hospital at about 3:15 that afternoon, you say, to your home.
No, did not say that.
When did you tell us today you got home from the hospital?
I got home from the hospital. For the first time I got home from the hospital was between 2:30 and 2:45.
And that's your recollection today? Oh, 15, 16 months after the events?
Of course, I have a great memory.
All right. You remember talking to a couple of law enforcement officers about this back on November 29, 2005.
Da, I remember Mr. Asbender. He was very nice to me.
Oh, I'm sure he was. And do you remember what you told them then about when you got home from the hospital?
Which time are you asking me? First time or second time or third time? I told a different story every time. Which time do you mean?
The time you told the truth, if you did, which I assume was November 29th, the first time you talked to them.
No, I don't recall.
Do you suppose that reviewing a report one of them prepared might help to refresh your recollection about that?
It might. You can try. Show me what you've got.
All right, I'm going to show you Exhibit 356, which is a Division of Criminal Investigation report, and invite you to look at page 3. The second paragraph may be the most helpful in refreshing your recollection, but you're welcome to read to yourself any or all of that report.
I think the witness is done, Mr. Strang.
Did that help refresh your recollection?
Da, it did very much.
Did you tell the police on November 29th that you arrived home at 3:15?
I might have. I do not know.
Well, do you remember telling them that or not? I need a definite answer.
Come on. I do not remember telling them that. It's been such a long time. I cannot remember everything.
But you said you have a really good memory. Well, okay, then do you think that maybe back on November 29 your recollection was a little better than it is today?
Looks like it, right?
Well, about events happening at that point, just 1 month earlier.
What was that, sir?
Do you think maybe your recollection back on November 29, 2005 was maybe possibly a little better than it is today?
I am not deaf. Yes.
Well, you seem to be having trouble understanding my questions. So, it was just 1 month after the events in question at that point.
Right.
Now, you get home, you very quickly get ready to go off deer hunting.
Da.
You are going to drive west from your home to go deer hunting.
Da.
Down Highway 147.
Da.
It's a 15-minute drive or something like that to your hunting spot.
Approximately. Da.
And this is when, on your way to go hunting, is when you see Bobbie Dassey.
That is correct.
And he's going east in the other direction on Highway 147.
That is also correct.
Now, Highway 147 at that point, if you know, what's the speed limit there?
Speed limit on 147?
Yes, if you know.
55.
55, all right. And the two of you, obviously, are going in different directions?
Yeah, obviously.
I said obviously, and so you pass each other, and you are later able to tell the police that Bobbie was going deer hunting.
Da.
Well, how did you know that?
How do I know that? Is because Bobbie was going to the trailer where I live to hunt behind it.
So let me understand this. He's going to hunt deer right behind your trailer.
Da.
But you don't hunt deer right behind your trailer.
It's a really bad spot, but occasionally I do.
And when did he tell you about this hunting trip that he planned right behind your trailer?
I do not recall him telling me. He had permission from the landlord to hunt there, and I obviously can read minds.
Okay, so you just figured since you saw him driving east on Highway 147, he must be going hunting.
Da, see?
Anybody else see you going west on 147 to go hunting, so far as you know?
I just told you it was Bobbie Dassey.
Uh-huh. And had you told him that you were going hunting?
No.
Well, how would he have known that you were going hunting?
He saw I had my camouflage clothes on. That's how he knew I was going hunting.
Objection, irrelevant,
Thank
Judge.
you. Sorry.
I'm going to overrule the objection.
You were in your camouflage coat.
Da.
In your green, not bluish green, Ford Ranger.
Yup. Green Ford Ranger.
Passing one another at 55 miles an hour?
Nope. Where I passed Bobbie, I probably was only doing maybe 25 miles an hour tops. I'm not a maniac. He was all slowing down to turn in my driveway, and I was driving up 147. Understand?
No, I don't, but we'll move on. And so you surmise that he would have known you were going deer hunting because he would have seen you in your camouflage clothing.
Da.
Did you go hunting with anybody that day?
No.
I want to go back just a moment because this was my mistake. November 29, 2005 was not the first time you spoke to law enforcement officers about Halloween, was it?
I do not recall.
Does November 10 sound more like the first time?
Da, that sounds more like it.
Okay, so about 10 days, 11 days after Halloween.
Da.
Correct? And on that occasion, you also told the police that you arrived home from seeing your mother in Green Bay at 3:15, true?
That is true.
Now, if I understand your testimony here today, you get back to Barb Yonda's home at about 5:15, something like that.
Da.
This is the home that she, at that point, shares with her 4 sons.
Da.
You see at that point Stephen Avery and Barb Yonda and one of the Dassey boys standing outside talking.
I do not recall them standing outside. I don't recall seeing anybody at that time beside Barb.
All right, and is it your testimony today that you don't recall seeing a fire in that burn area there behind?
Oh, I seen a fire there. Big fire. It was a very big fire. Never will I forget about that.
Oh, you did see the fire there.
Oh, yeah, I did. Big fire.
At 5:15?
I do not recall seeing a fire at 5:15.
All right. When do you tell us today you first recall seeing the fire? In the burn area.
I first remember seeing the fire.
Mr. TADYCH, let Mr. Strang finish his question first.
Fire burn area behind garage. Today, when did you tell us you first saw that fire?
Oh my God, you really do not understand. I really remember first seeing it the second time I was there.
Well, would it help to look at Exhibit 356 again to see what you told the police on November 29th?
Objection, Your Honor. He hasn't claimed any lack of memory.
Do you recall telling the police on November 29 that you saw a fire burning in the area behind Steve's garage between 5:15 and 5:30?
Just a minute. You can ask him the question, but let's pull the exhibit away.
Okay. Do you recall telling the police, the officers, that between 5:15 and 5:30 on October 31st, 2005, you saw 2 people standing around a fire that was burning in the area behind Steven's garage?
That was the second time I seen him standing when I came back. I don't recall.
You don't recall telling the police you saw that between 5:15 and 5:30?
Not that. No, I don't recall that either.
All right.
I seen it the second time. I was there twice.
Well, then take a look again at Exhibit 356. That's not the one I want. I show you Exhibit 357, a DCI report, interview with you that occurred on November 29, 2005. Again, look at any part of it you like. The third paragraph on that page may be the most helpful in refreshing your recollection. All done? Having looked at that, does that refresh your recollection about what you told the police on November 29?
It does.
Did you tell the police on November 29 that between 5:15 and 5:30 p.m. you saw two people standing around a fire burning in the area behind Stephen's garage?
You are very good. You got me there. I did.
Memory fresher than it is today?
What was that, sir?
Is your memory fresher today, or was it fresher back on November 29, 2005?
Fresher back on the 29th of November, of course. I'm a human being like everybody else.
Okay, and is that if I understand you today, you're telling us that when you see the fire later, sometime after 7:30, you think the flames were almost as high as the garage? Maybe 8 to 10 feet?
It was a big fire I was telling before to Mr. Kratz, and it is still a big fire. Yeah, big fire.
Well, was November 29 also the day that you told the police that the flames were at least 3 feet high? At least that high?
Must have.
Well, whenever you saw this fire, and however many times you saw it, you smelled nothing strange coming from the fire.
No, I smelled marshmallows.
You heard no one screaming?
No.
And you heard no gunshots?
No.
You didn't see Mr. Avery trying to conceal himself in any way?
No.
Especially at 7:15, 7:30, when you drove up, you would have driven up the driveway with your headlights on.
Da.
It was after dark, right?
Da.
And as you drove west down this lane, as I understand your testimony, then you swung into the driveway this way.
No, it was the other way around.
You came in this way?
Da.
But you parked over here?
Da, your orientation is terrible, sir.
All right. So you would have had your headlights on until you parked the car and turned it off.
I didn't shut my car off.
You had the headlights on the entire time?
If the car was on, of course the headlights were on.
Oh, now, if I understood you as well today, you have told us that Barb came to your house a little later that evening.
That is correct.
And you dropped her off, right? She goes into the house.
I don't know what she did. She's a woman. I'm a man.
You dropped her off. You presume she went in the house.
I hope she went into the house, yes.
Oh, and then shortly later, she appears at your house.
She didn't appear. She drove.
Barb, by the way, at that time, was married to your cousin, Tom Yonda.
Yeah, she was, but it wasn't going well between them.
Oh, apparently, separated or whatever.
Da, we were screwing around. No.
But the name Yonda comes from your cousin, Tom Yonda.
You're absolutely right.
Okay, and so she comes to your house and the two of you are going to watch television.
Correct.
And you remember specifically that you wanted to watch a show called Prison Break.
That is totally correct. It is a wonderful show. I want to learn something from that show.
Is that something you were recording on the VCR?
No.
Or TiVo, something like that?
No.
You were going to actually watch it as it was broadcast?
Why is that so strange? That's what you do with the television program. You watch it.
which is why you think you got home at 8 o'clock.
That's exactly what I wanted to be home.
Now, she stays and the two of you watch that show.
Correct.
You have a memory of watching that show?
Da.
And then your recollection, as you told us today, is that she leaves somewhere around 10:30 or 11.
Correct.
You're quite sure that she leaves and goes home?
Well, I do not know. I told before. I once said she went home, then I said she stayed the night. I say yes to your question today. Okay? Good?
So I'm going to repeat that question because I'm not quite clear what your answer is. You're quite sure that she leaves and goes home?
Okay.
Yes or no?
Yes, okay, oh yes.
Thank you, thank you. Well, you talked with the police yet a third time, I guess at least, didn't you, after November 29th?
I may have.
March 30th, 2006. Does that sound about right?
Could be.
Okay, and Investigator John Dietering from the Calumet County Sheriff's Department.
Could be.
Do you recall telling Investigator Dietering that Barb spent the night at your residence and did not go home, and that you knew she did go directly to work from your residence, to your knowledge?
See, you know what I was talking about, but I do not recall that.
You don't recall that? Okay. Do you think reviewing Investigator Dietering's report might help refresh your recollection about that?
I am so totally sure it will.
Okay, it is. I'll show you Exhibit 358. Investigator Dietering's report of his interview with you on March 30th, 2006. Read to yourself any part of it you like. The very bottom on the first page might be the most helpful.
Are you done, Mr. TADYCH?
No.
Are you done, Mr. TADYCH?
No.
3 hours later.
Yes.
I believe he's ready.
All done? Does that help refresh your recollection?
I guess it does, yes.
Okay, well, it should after reading for 3 hours. About what you told Investigator Dietering. Did you tell Investigator Dietering on March 30th that Barb spent the night at your residence and did not go home? Barb did go directly to work from your residence, to your knowledge.
I did.
Barb works an early morning shift, at least at that time.
That's what she told me. I hope she's going to work.
Until sometime in the mid-afternoon.
That is true, yeah.
So sometime around the time that you talked to Investigator Dietering, on the occasion you just described, were you trying to sell one of the Dassey boys' 22s to a man named Jay Matheson at work?
No, that is not true. No.
You weren't? Are you sure, though, that you watched the show Prison Break starting at 8 p.m. on Monday, October 31st, 2005?
Am I sure?
Yeah.
Of course I am.
Are you sure of that?
Maybe not.
As you are of anything you testified?
Maybe not.
Here, stop talking over me. Wait till I finish my question before you attempt to answer, please.
Whatever. But I'm sure that's what I went home to watch.
Okay. You are sure it was 8 o'clock?
Da.
As sure as you are...
I'm sure it was 8 o'clock. I am not that stupid.
Are you as sure of that as you are of anything you testified to here today?
Oh my God, I guess not. I do not know anymore.
Mr. Kratz, anything else?
Mr. TADYCH, Mr. Strang asked if your recollection was clearer earlier.
It was clearer earlier, of course.
You really are going to have to wait until I finish the question. Whether your recollection was clearer, that is, as you got closer, or were earlier in time, specifically November of 2005. Do you remember both of your first 2 interviews with law enforcement?
I remember the first 2.
And do you remember in both of those interviews telling law enforcement officers that Barb left your house sometime between 11 p.m. or midnight and went home those nights?
What are you talking about? You asked me that question before and the time was 10:30, 11 p.m. and now it is 11 p.m. or midnight? Yes, I assumed she went home. I thought she did. Okay, am I done here today?
That's all I have of Mr. TADYCH.
All right, the witness is excused. You may call your next witness, Mr. Kratz.
Call Bobbie DOHRWARDT to the stand. Could I just have a minute with Mr. Strang, Judge?
Sure. Excuse me, counsel. I think the witness is standing right behind you.
Raise your right hand. Please be seated. Please state your name and spell your last name for the record.
My name is Bobbie DOHRWARDT, DOHRWARDT.
I'm sorry for the delay, Ms. DOHRWARDT. Can you tell the jury, please, how you are employed?
I work for STAHLKE.
And what is STAHLKE?
STAHLKE is a wireless carrier local to Northeast Wisconsin.
Ms. DOHRWARDT, have you been asked and have you reviewed cellular telephone records for a subscriber by the name of Stephen Avery or Avery Salvage, Auto Salvage, for the dates on and around October 31st, 2005?
Yes, sir.
Let me ask you, Ms. DOHRWARDT, in your employment with STAHLKE, are you what is known as one of the custodians of the business records for that business?
Yes, I am.
Generally, what do you do for STAHLKE?
I'm the team leader for the technical support department.
And as team leader, are you able to review and to the extent that, at least in general terms, we're going to ask you questions. Are you able to interpret cellular telephone records that you have been asked to look at?
Yes, sir.
The court has asked, Judge, and I think Mr. Strang will agree, that we not use telephone records in this instance. Telephone numbers in this instance. And Ms. DOHRWARDT will be referring then to subscriber names rather than numbers. And please, Mr. Strang, if there's an issue, stop and we can either approach the bench or we can approach the witness at that time. Does that sound fair, Judge?
Your Honour, this actually will be Mr. Buting's witness, but we do have an agreement that for purposes of this trial, we'll not identify specific telephone numbers, at least without conferring further.
Very well.
Ms. DOHRWARDT, the first document that you have in front of you, which is actually quite small print, I would ask you to identify that document number for me, please. What exhibit number is it?
Exhibit 359.
And could you tell the jury, please, what Exhibit 359 is?
It is a call record that I produced.
And was this the call record, again, for both incoming and outgoing telephone calls for the cellular telephone records for Stephen Avery?
Yes.
Again, do these include calls on October 31st of 2005?
Yes.
If I ask you at a specific time, and if you have another record next to you, which I think is exhibit number 360, please feel free to refer to that if that will assist you. Does that sound okay?
Fine.
Let me ask you then, Ms. DOHRWARDT, at 8:12 a.m. on October 31st, 2005, was a cellular telephone call placed from that cellular telephone of Stephen Avery?
Yes.
And again, referring to exhibit number 360, since that will refer to subscriber names rather than numbers, can you tell us who that call went to, please?
That call was to Auto Trader.
And how long and what was the duration of that call?
2 minutes, 47 seconds.
I would next ask you to review an outgoing call at 2:24 p.m. Do you note that calling having been made?
Yes.
And again, referring to exhibit number 360 and exhibit 359 in conjunction, are you able to tell who that telephone call was made to?
To Teresa Halbach.
What is the duration of that call?
7 seconds.
Now, Ms. DOHRWARDT, I'm going to ask you about a specific cellular telephone feature, which is called the *67 feature. Are you familiar with that?
Yes.
Could you explain that to the jury? What is a *67 feature?
It is a remote feature activation that will allow the outbound number to be blocked or restricted on the terminating end.
If the individual on the receiving end had, let's say, caller ID, you may have a better term than that, but if they had what we all know as caller ID, would they be able to see who the call is being made from?
No, it would appear as blocked or restricted, private, something like that.
And next, Ms. DOHRWARDT, I'm going to ask you to review those records again, Exhibit 359 and 360. Ask at 2:35 p.m. if another call, outgoing call, was attempted from the cell phone of Mr. Stephen Avery.
Yes.
And who is that call placed to?
Teresa Halbach.
Is there a duration, or was that a completed call?
There was no duration.
All right. Now, both the 2:24 call and the 2:35 call, do your records reflect that any specific call feature was used on those calls?
Yes.
Which call feature was used?
The *67 blocking feature.
At 4:35 p.m., Ms. DOHRWARDT, does another outgoing call appear on those records?
Yes.
Who was that call made to?
Teresa Halbach.
And is there a duration noted on that call?
No duration.
So duration would be 0?
0.
All right. At 5:57 p.m., do your records reflect another call being made?
Yes.
And who was that call made to?
Charles Avery.
And can you describe for the jury the duration of that call?
5 minutes, 23 seconds.
Finally, Ms. DOHRWARDT, at 9:20 p.m., do your records reflect the final outgoing call that day?
Yes.
And who is it that call made to?
Barb Yonda.
And is there a call duration associated with that call?
0.
Now, we have talked about exhibit number 359 being your records, that is, the records of STAHLKE. Does exhibit number 360 appear to be, legal term is a summary exhibit of what you have testified to here today?
Yes.
And do the numbers or times of the calls, type of call, the call durations, all appear consistent with not only the records in 359, but also with what you have testified here today?
Yes.
With that then, Judge, I will move the admission of Exhibit 359, provisionally 360, and maybe an additional stipulation with that exhibit. But I don't believe I have any further questions of Ms. DOHRWARDT at this time. Thank you.
Any objection to the exhibits?
No objection.
All right. The exhibits are received.
Can we approach, Your Honor?
Sure. All right, members of the jury. We're going to take our afternoon break at this time. We'll resume in about 15 minutes. All right, we'll resume in 15 minutes. Mr. Buting, you may proceed.
Thank you, Your Honor. Good afternoon, Ms. DOHRWARDT. Just a couple of quick questions first, and then I'm going to return to these exhibits that you've been referring to, all right?
All right.
This *67 feature, that's actually available on other lines as well, landlines, right?
Right.
And that's something that the caller uses if they would want to not allow the receiving party to see what the phone number they are calling from is, right?
Right.
But it doesn't remove it from your phone bill. It still shows up on the customer's own phone bill, right?
Right.
Okay. So it's not like it's a call that becomes invisible if you use *67. It is still in your own records. The customer's own calling records would show the phone number that the phone call was made from, right?
Are you referring to STAHLKE, how they bill, or another carrier?
Just in general, if you get an itemized bill, it will be on there as an outgoing call, right?
STAHLKE only bills for answered calls with duration.
All right.
So
if it was answered, if you use the *67 call to somebody and it's answered, it will show up on your bill as an outgoing call.
yes,
Okay.
but it would not show the restriction.
Pardon?
It would not separate from.
Sure. It will be on there though.
Right.
Okay, so Mr. Avery's bill would show he made a phone call to Teresa Hallbach each one of those times, whether or not the *67 feature is used, correct?
If it was answered and there was duration, yes.
Sure. Okay. Well, let's go into that little issue that you just brought up, answered or not. Do you have Exhibit 360 in front of you?
Yes.
And then I'm going to put this up on the Elmo because this is testing the limits of my eyes. Exhibit 359, that's the basis really of your testimony today, your knowledge, right?
Right.
Exhibit 360 was not prepared by you though, right?
Right.
That was prepared by the prosecutor just as sort of a summary exhibit of what your testimony would be.
Right.
Okay, if you don't mind, I'm going to take both of these away from you for a moment, and I'm going to put them up on the screen, okay?
All right.
Counsel, one thing. Weren't we trying to avoid the numbers? Are you going to show the telephone numbers on the screen?
Yes, I would prefer, Judge, that only 360 be put up on the screen.
No other way, Judge. If you want to order the cameras not to...
All right. I will ask the television cameras in the courtroom then, not to show the screen while the telephone numbers are on there. That would be Exhibit 359.
That is correct.
Okay, or Exhibit 360. When it's back to the names, if the television cameras wish to show the screen, they can. Which one are you doing first, Mr. Butane?
I'm going to do 359 first.
Alright, 359.
I just want to show you first, make sure we know what we're talking about here. 359, which is this very small font because you're trying to get, whoever printed it is getting a long line of columns into a little 8.5 by 11 piece of paper, right?
Correct. Actually, both pages side by side would be the entire record.
Oh, it actually goes out 2 full pages. You're right.
Correct.
Okay. All right, I'm going to zoom in here. First column. Well, it has a number, like a sequential number on the phone call for this particular record, right? 70, 71, 72.
Right.
The next column is C's date and time. Now, if I understand what that is when someone makes a call and it gets connected to one of the cell towers, the time begins running, right?
Correct.
The call is seized, whether or not it goes beyond that, right?
Correct.
And then if you look at the fourth one up from the bottom, do you see the number here, 1435?
Yes.
That is a time, right?
Right.
That is 2:35, right?
Right.
And the third one up from the bottom is 16:35, which actually is 4:35 p.m., correct?
Right.
Okay. Now, and the one right above, I'm sorry, I should have started with this one. The sixth one or fifth one up from the bottom, 1424. This call that's placed by Mr. Avery's cell at, I hate these military times. I'm sorry, 1424 is 2:24 p.m., right?
Right.
That's call number 61.
81.
81. Okay. I should have blown it up more. If we follow along here, the next column is the answer date and time, right?
Right.
And then the next one over is the release date and time, right?
Right.
And then the next column is the answer indicator column, right?
Right.
And that call says answered in that column, doesn't it?
It does.
And the call right below it, which is the one that was made at 2:35 p.m., says not answered, correct?
Correct.
And the call at 4:35 p.m. to Ms. Halbach's phone also says answered, correct?
Yes.
Now, we're going to have to remember the order of these because I've got to turn to the next page. And I don't think you have numbers on there. Let's look at first call number 83, which is the third one up from the bottom, okay?
All right.
That's the call that was made at 4:35 p.m. from Mr. Avery's cell phone to Teresa Halbach, right? Are you still with me?
Yes.
The one that says answered over here in that column, I'm going to turn to the last page because of this exhibit. Because the last columns, almost the last columns in this exhibit give us the duration of the phone call, right?
Right.
And if we look then at the third to the bottom call line here, the call from Mr. Avery's phone at 4:35 p.m. on October 31st to Teresa Halbach's phone has a seized duration of 62 seconds, right?
62 hundredths of a minute.
Oh, okay.
3-1.
And it does not have a duration of 0, does it?
It does not.
Is that the third one up or the fourth one up?
This is the third one up. Do you want to see the first page again?
Yeah.
Okay.
Okay. So it's the 4:35 call you are talking about.
4:35 call.
Okay.
It is the third one up.
Very well.
And would you agree with me that this exhibit shows that it has a duration, seized duration of 62 or 062 and a call duration of 0.18?
I do.
Okay. And the next one above it has a duration of 0?
Right.
And the one above that has a duration of 0.12.
Correct.
And back to the first page, the one directly above the 4:35 call that we were talking about is the one that's made at 14:35 or 2:35 p.m. That's the one that says it's not answered.
Right. There's more to these calls, though.
And that one is clearly not answered at all.
Not answered. And the release cause shows the calling party hung up before anything answered the call, voicemail, or a person.
Okay, the one above it, though, at 2:24 p.m. is answered, right?
Yes, but again, I can't say by a person or by voicemail.
All right. So we don't know whether the call goes, these records don't tell us whether the call goes into voicemail or whether it's answered by a live person.
If it was a STAHLKE customer, I could see that, but not when it's another carrier.
All right. And let me just go back to this call. You also testified about a call at 5, or Exhibit 360 refers to a call that Charles Avery at 5:57 p.m. That would be the second to the last row, right?
Right.
1757. And that one is answered, right?
Right.
And your Exhibit 360 says the duration was 5 minutes and 23 seconds. This exhibit says 538?
It says 5.38 minutes.
Okay. So you divide that into, you do a calculation and figure out that 0.38 minutes is 23 seconds. Is that how you did it?
Right.
Well, in the call above it, it says 0.18. You said the duration is 0 on this Exhibit 360. It's really not 0, is it?
The call duration is, yes.
Call duration says 0.18, correct?
Well, I'm confused on which call we are on now.
Well, third from the bottom, where it says we have established is the call at 4:35 p.m. for Mr. Avery's call to Teresa Hallbox.
That would be 11 seconds.
So this exhibit then, 360, is wrong?
Judge, I'm going to object as argumentative. She clearly wanted to explain it. Mr. Buting hasn't let her.
We're going to do that right this moment.
Well, then don't call it wrong.
All right. That question to me allows an answer, so you can explain.
Thank you, Judge.
Your answer.
Answered, as far as an answered call, being able to tell if it was answered actually by a phone or by voicemail, unable to tell that. And the durations of Exhibit 360, since I have a cease duration and call duration, both columns on my report. I'm not sure which of those numbers was taken for 360 to say that it was right or wrong.
Right. Well, what we have just established now, though, today is that the call was made from Mr. Avery's cell phone to Teresa Hallbox's cell phone at 4:35 p.m. According to your records in Exhibit 359, Cellcom records, is marked as answered, right?
Correct.
And has a duration not of 0, but of 11 seconds, right?
Correct.
And similarly, well, that's okay. We'll leave it with that. So you would suggest that we correct Exhibit 360 so that in the last column where it says duration on that call to Teresa Hallbox, that it actually say 11 seconds instead of duration 0.
Objection, Judge. It's a mischaracterization.
Well, I'm going to let her explain, or answer the question.
Looking at that specific call, something did have answer with the call.
Okay.
Whether, again, I can't say a phone or a voicemail system. Either would cause that result, but the connection was up for 11 seconds.
So then why does Exhibit 360 say 0?
I don't know if that's because of how the other carrier shows whether it was answered or not, and how I can't explain how their records work, how these numbers come to me.
Right. Well, if this Exhibit 360 is being introduced through you, presumably it's based on your knowledge of Cellcom's records.
Correct.
Or is it?
Well, I just saw this for the first time today, so I apologize. I did not see that particular call.
Just for the court's clarification, did you prepare Exhibit 360?
No.
Okay. I'm not trying to beat up on you, ma'am. I'm just trying to clarify. I understand that you didn't prepare 360. What I'm asking you is now, looking at the record yourself from your own records, would you suggest that perhaps the Exhibit 360 in front of you be amended? If not corrected, amended to show on the duration column 11 seconds?
Yes.
Thank you. That's all I have.
Let me ask,
Mr. Kratz.
Ms. DOHRWARDT, if you reviewed, as you have in this case, other records, that is, records other than records from Cellcom, would you be able to give the jury a full explanation of what happened with that call at 4:35?
I don't understand the question.
Are there other records that you have reviewed regarding that specific call at 4:35 p.m. that better explains what happened with that call other than your Cellcom records?
Yes.
What other records?
Let me object. If she's not testifying from her own records, she's unable to authenticate or explain someone else's records. This witness, if another witness can do that, fine. This witness, as I understand it, is qualified to interpret Cellcom record, and she's done that.
Let's ask her, Judge.
Yeah, we don't know yet whether in a sense, both of you are right. She hasn't been qualified yet, but I can't say for sure that she won't be qualified. So, Mr. Kratz, you may proceed.
Thank you, Judge. Is 359 still floating around somewhere?
Did I grab it?
Ms. DOHRWARDT, I have now handed you what has been marked for identification purposes as exhibit number 361. Have you seen that document before?
Yes.
In providing the information for exhibit number 360, the summary exhibit, which, as Mr. Buting correctly indicates, is an exhibit created as a summary of voluminous information. Did you look at exhibit 361 and assist in the interpretation of those records together with your records of exhibit 359?
Just a second. Before we go further, I think we should identify what exhibit 361 is.
I would be happy to do that, Judge. What is exhibit number 361?
Exhibit 361 is a type of a call record activity from Singular.
And do you know what Singular is?
They're another cell phone provider.
And do you know if Singular wireless records that are contained in exhibit 361 tell the other side of the story, for lack of a better term, from what the caller records from 359 tell?
Objection. She's still not been qualified to be able to interpret these records.
I assume that she's in the process of being qualified. You may be right, maybe she won't be qualified, but I think this is a foundational question as I understand it.
These records have a lot of the same information that STAHLKE records have, but a lot that we don't. They're missing a lot that our records have. So you can't see on the calls of these particular times who actually the calling number was on those, where our show inbound and outbound. But these do show communication between the phone and the network, durations, outbound numbers if they were dialed. And that's it. That's all that's on these records.
Exhibit 361 also shows something called a tower site or a tower designation. Is that correct?
Correct.
Now, let's go back to the qualification, your qualifications. As technical research team leader, as in fact the manager of tech support for Cellcom, are you familiar with interpreting that kind of data and that kind of information?
Yeah.
In fact, you do that every day?
Correct.
Which kind of data are we referring to? The question is not clear.
She has to be qualified to interpret the exhibit 361, the records from a competitor.
I understand that, Judge.
That's where you are going?
Yes. Are you asked to interpret information? And the specific column that I'm interested in is cell designation and cell site information. Are you asked to interpret that kind of information every day?
Yes.
And specifically, as you look at exhibit number 331, are you able...
361?
Oh, 361. I'm sorry, Judge. Ms. DOHRWARDT, are you able, in looking at exhibit number 361, to provide assistance, to provide an explanation as to a call made at 4:35 p.m. on March 31st of 2005? I'm sorry, 4:35 p.m.
Well, I can...
October 31st. I'm sorry.
What I can say about these records is that communication between the phone and some cell site, which I can't convert because I don't have a chart to tell what these numbers mean as far as what cell site, but they clearly show that there's communication between the phone and a site for every call up until that call. And then there is no further communication with that phone and any cell site after that time.
Based on your training, based upon, I assume you have been doing this for a while?
Yes.
How long have you been doing this?
4.5 years.
And are you trained to interpret and provide opinions on data such as in Exhibit 361?
I have not been trained in other carriers' records and how they pull them, but being how similar that they are, I feel comfortable with that I'm looking at.
All right. Ms. DOHRWARDT, recognizing it is singular and not Cellcom, recognizing that difference, okay? Which is, I think, what you testified about?
Yes.
Are you able, I'm not going to ask yet for your opinion, but are you able, looking at those records at exhibit number 361, to provide an opinion as to whether that particular call had a duration? That is, as to whether that was a completed call. That is, completed with a human being on the other end of the line.
There is no cell site on that call, but there is the duration matching.
Objection, Your Honor.
I'm just asking, yes or no, if you're able to render that opinion.
Oh, yes.
Judge, I don't know if Mr. And I want to give Mr. Buting an opportunity to voir dire. I am going to ask that opinion, but if there's...
Well, let me ask this. Do you have a singular person coming in?
Yeah, why don't we do it then?
Is there going to be a witness from singular?
Yes, Judge, but I want to be heard. We can't. If this witness is qualified, I think I'm entitled to ask her that question.
He's asking for an expert opinion now. She's not just a custodian. If there's a witness available, let's just move on.
She indicated that it's not her company and they don't have all the information on the form. However, she also said she's qualified to interpret this particular information, and I believe under our rules for expert witnesses, I believe that's sufficient. So I'm going to let her do it.
Did you understand my question?
Your Honor, there's been no disclosure of her report then under 971.23. If she's now going to convert this witness, a custodian, into an expert.
She's just interpreting the data, Judge, and I don't know that she's issued a report or written report on this. In fact, I'm quite sure she hasn't.
Any summary of her opinions that are anticipated to be presented. We've been through this before.
All right, let's save it for the next witness. As I understand it, your summary exhibit is a compilation of information that you anticipate eliciting from more than one witness, correct?
Yes, and it's from two witnesses, Judge. This witness is necessary to complete Exhibit 360.
As is the next witness.
I understand that, but the suggestion that is now left before this jury is that it's somehow an error. And with this witness, I can clear that up. She's qualified to do that, and I'm asking for leave to do that. If the court is saying no, then we'll move on.
I don't agree with your characterization. I think the only conclusion it draws at this stage, Exhibit 360, is incomplete because it's a compilation of information you're going to be eliciting from two separate witnesses. So let's limit this witness to what the witness has to say about STAHLKE, and then you can go back to the Exhibit 360 when you bring in the singular witness.
I will, at this time, Judge, not ask this witness any questions. I'm alerting counsel and the court that I may recall this witness after our next witness.
Fair enough. Any more questions, Mr. Buting?
No, I don't believe so. All the questions were regarding the other witness, so we'll wait for the witness.
All right, you're excused at this time, and the state may call its next witness.
Thank you, Judge. We'll call Laura SCHADRIE to the stand.
Please raise your right hand. Please be seated. Please state your name and spell your last name for the record. Laura SCHADRIE, SCHADRIE.
Ms. SCHADRIE, what is your occupation?
I am manager of Singular Store.
Where is your business located? Where is your home office?
Home office is located in Atlanta, Georgia.
Where are you physically located?
Fond du Lac, Wisconsin.
All right. Ms. SCHADRIE, as a manager, Singular, by the way, is a wireless phone service, is that correct?
Yes.
Ms. SCHADRIE, as a manager, as a person in management for Singular, Are you familiar with and have you been asked to review various cellular phone records specifically for a singular customer by the name of Teresa Habach?
Yes.
Miss SCHADRIE, were you asked to review those records and calls placed, both incoming and outgoing calls, from October 31st, 2005, for that singular customer?
Yes.
And prior to coming to court this afternoon, have you, in fact, reviewed those business records?
Yes.
And are you what's called a custodian of those records?
Yes.
Miss SCHADRIE, I'm going to have you look in front of you at, I believe it's Exhibit 361. Do you recognize those records?
Yes.
What is Exhibit number 361?
It is the call records that I have reviewed.
Now, I understand that, and so that the court is clear about your last answer, you have been asked not to discuss or broadcast any specific telephone numbers in this case. Is that right?
Yes.
Because of that, there are two other documents in front of you. One is Exhibit number 360, and I think is Exhibit 362. Do you see those?
Yes.
Miss SCHADRIE, are you able, in reviewing Exhibit number 361 and in conjunction with 362, at least as that relates to names rather than telephone numbers, of providing this jury with a summary of telephone calls, both incoming and outgoing, from Teresa Habach's cellular records dated October 31st, 2005?
Yes.
I'm first going to ask you to look at a telephone call at 9:46 a.m. And again, feel free to compare and to use both documents if they will assist you. I'm going to ask you first of all if that was an incoming or an outgoing call.
That was incoming call.
And who was that received from?
Auto Trader.
Time of call?
33 seconds.
And you're meaning the duration of the call, is that right?
Yes.
All right. And just so the jury understands, those records wouldn't provide you with any detail as to the content of the call or what it was about or anything like that. Is that right?
Right.
Just the time of the call and the duration of the call and who it may be from, at least a telephone number or a name. Is that right?
Yes.
All right. Second call I'm going to ask you to refer to is a call at 11:04 a.m. Do you see that call?
Yes.
Was that incoming or outgoing?
That was an outgoing call.
And who was that call to?
Voicemail.
And how long was that call?
1 minute and 55 seconds.
The next call I'm going to ask you to describe is a call at 11:27 a.m. Do you see that?
Yes.
And was that incoming or outgoing?
That was an outgoing call.
And who is that to?
Voicemail.
And how long was that call?
2 minutes and 55, 2 minutes and 56 seconds.
All right. Now, when you talk about voicemail, those of us in the courtroom and those jurors that don't have voicemail, what is voicemail?
A voicemail is when a caller leaves you a message and you are not able to answer your phone call, and when you would call your voicemail to retrieve any of your unheard messages.
Okay. Next call I'm going to ask you to refer to is at 11:43 a.m. Do you see that?
Yes.
Is that incoming or outgoing?
That was an outgoing call.
And who is that to?
Bar Pianda.
And how long was that call?
1 minute and 5 seconds.
Next call I'm going to ask you to identify is at 12:39 p.m. Was that incoming or outgoing?
That was an outgoing call.
And to whom?
That was to voicemail.
And what was the duration of that call?
33 seconds.
The next call I'm going to have you identify is at 12:51 p.m. First of all, was that incoming or outgoing?
That was an outgoing call.
From or to whom? I'm sorry.
Stephen Schmitz.
And for how long was that call duration?
46 seconds.
Do you see another call at 2:12 p.m.?
Yes.
And was that incoming or outgoing?
That was an outgoing call.
To whom?
George Zipperer.
And how long was that call?
1 minute and 9 seconds.
Next call is at 2:13 p.m. Can you describe that for me, please?
That was an outgoing call to voicemail.
And how long did that take?
37 seconds.
Now, do you see a call at 2:24 p.m.?
Yes.
And do you know if that was incoming or outgoing?
That was an incoming call.
Now, are you able from your records to determine who it was from?
No.
And how long was that call?
8 seconds.
Next call I'm going to have you identify is at 2:27 p.m. Do you see that?
Yes.
And was that incoming or outgoing?
That was an incoming call.
And from whom?
Auto Trader.
And how long was that call?
4 minutes and 45 seconds.
And finally, I'm going to have you refer to a call at 4:35 p.m. Do you see that?
Yes.
Was that incoming or outgoing?
That was an incoming call.
And from whom?
Stephen Avery.
And what was the duration of that call?
13 seconds.
Now the summary exhibit, that is exhibit number 362. Does that set forth the type of calls, who they were sent or received from, the time of the call, and the duration, as you have testified here in court?
Yes.
And have you looked back, however, at exhibit number 361? Those are your singular records themselves, is that right?
Yes.
I want you to look at the column that deals with cell site information, or where a call may be placed off of, or what's called a hit off of. Do you see that column?
Yes.
All right. Specifically, the call at 4:35 p.m. Do you see that call in your records? 361?
Yes.
Now, does the call at 4:35 p.m., does that appear to have been a completed call? Meaning, did that call hit off of any cell sites that your records reflect?
I don't know.
Does it show in the exhibit whether or not it hit off any cell site?
No.
No, it doesn't, or no, it didn't.
It doesn't show that it hit any cell site.
Okay. Now, as a manager, are you required, or do you perform any technical research or provide any technical opinions for Singular?
No.
Are there tech people? In other words, are there technicians or people in your technical research department that do that kind of thing and render those kinds of opinions?
Yes.
So you are here today just as the custodian of those records. Is that right?
Yes.
With that, Judge, at least with Miss SCHADRIE, that's all the questions I have. I would move the admission of 361 and 362 at this time.
Any objection?
Yes, but I would like to be heard outside the jury as to the summary of those only. But we can hold off on that and do the cross.
By summary exhibits, we're talking 360 and 362?
Yes.
Very well. Other exhibits are okay.
361 and 359, I have no objection.
Okay, those are admitted, and Miss Abuting, you may commence your cross.
Thank you. Good afternoon, ma'am.
Hi.
Do you still have the exhibits in front of you there?
Yes.
361 has a call on it, call number 7. That's 4:35 p.m., right?
Yes.
Doesn't actually have a number. In the column, it says dial number. There's nothing listed there, right?
Yes, correct.
And that's true of a lot of these calls that are on this particular exhibit, right?
Yes.
But anyway, in this one, it does show that a duration is 13 seconds, correct?
Yes.
It's not 0, right?
Right.
Okay. And you can't tell from this whether the call went into voicemail or not. Possible?
Right.
Okay. And just so we're clear, Exhibit 362 that's in front of you, the summary exhibit, does not include all of the calls that were made to and from Teresa Halbach's phone on October Halloween 31st, does it?
Right.
And in fact, if you look at Exhibit 361, there is a call at 2:41 p.m. that has a duration of 1 minute and 20 seconds, correct?
Yes.
And that does show a cell site, right?
Yes.
Judge, I'm going to object as irrelevant unless Mr. Pudding wants to admit that there is a relevance that it shows a cell site in there.
I'm just pointing out what's on the record at this point.
Does it have any relevance?
Well, how about this relevance? It's the last phone call on Teresa Halbach's record that shows an actual cell site location. I think that's pretty relevant.
I will absolutely stipulate to that, Judge. That's the last call that ever made it to Ms. Halbach's. That's right.
I'm not stipulating to that. I'm just saying it's the last one with a cell site on it.
I'm gathering from what you are saying, both saying, that at least it has some relevance, so I'm going to allow the question.
So, for instance, the 241 calls says a minute and 20 seconds duration, right?
Yes.
And those records don't tell us, if I understand, whether or not a phone call gets sent into a voicemail or not.
Correct.
And there's also a call, this may be compound, but I will ask it anyway. There was a call at 1:52 p.m., right?
Yes.
That's not on Exhibit 362, correct?
Correct.
There was a call at 12:45 p.m., right?
Yes.
It's not on Exhibit 262, right?
Correct.
And neither of those calls show the number that it's coming from.
Correct.
There's another one at 12:29 p.m., correct?
Correct.
And all three of those last numbers I mentioned are incoming calls.
Yes.
You can tell that because an outgoing call or outgoing call from her phone would have the phone number that's dialed.
Right.
So, for instance, that's the last actually dialed number that's reflected on here is at 2:13 p.m. That is on Exhibit 362, and that has a long number that apparently is the voicemail.
Yes.
Which is actually a 414 number.
Yes.
Okay, is there anything in this exhibit, number 361, that tells you the names of these people that you testified to that are on Exhibit 362?
No.
So when you said, for instance, a phone call to George Zipperer at 2:12, that is not actually reflected on 361, is it?
Correct.
And you didn't prepare 362, did you?
No.
And the phone call that you mentioned that 362 says was given to Stephen Schmitz, you can't tell that from your record, Exhibit 361, either, can you?
Correct.
And even the call to Barabyanda at 11:43 a.m. reflected on 362, you cannot tell that from your own records, 361.
Correct.
All right. Let's talk about voicemail for a minute. You are familiar with that, right?
Yes.
if somebody wants to call their own voicemail from their own singular phone, do you have to enter a password?
No.
So you just push some buttons and it goes automatically?
Correct.
Okay. If somebody wants to call voicemail from a landline, though, say the owner of a cell phone is trying to pick up their messages on a landline, they would have to enter some password, right?
Yes.
And when one does that, if you're on a landline, or I'll broaden that just a little bit, whether you are calling for a landline or your own cell phone, when you call it, it will tell you, give you a message that you have 5 new messages, something like that, right?
Yes.
And then you push a button and you listen to all 5 of those messages, right?
Yes.
Once you do that in your records, those are considered opened and listened to. They're still on your system, but they're considered opened and read, right?
Yes.
If there are phone messages in your voicemail that you don't open and read, they're reflected in your records as unopened.
Yes.
So if your records show that on a certain date, let's say, we'll just pick a date, November 5th of 2005, okay? If your records were to show that messages were opened all the way up to that date on Teresa Halbach's phone, that would mean that somebody had listened to those voice messages.
Objection. Speculation, Judge.
I guess she can answer it.
I haven't heard of foundation. Perhaps he could lay some foundation with his witness.
All right, that's fair.
You understand singular records, right?
Yes.
You understand singular's voicemail process, right?
Yes.
And you understand how they mark messages incoming opened or incoming unopened, right?
Yes.
And incoming old, you know what that means as well, right?
Yes.
Incoming old would mean messages that have been already listened to and are still on the system.
Right.
Incoming unopened would be messages that are on the system that no one has ever listened to.
Right.
All right. And then incoming new would be a brand new message that's come in, probably the most recent one, right?
Correct.
Judge, I would like to be heard outside the presence of the jury, please.
All right, at this time the court will excuse the members of the jury. We'll excuse the witnesses from the courtroom as well. You can step out in the hallway.
Judge, actually...
All right, I believe the jury and the witness are both out of the courtroom at this time.
Actually, I think we might need this witness to be able to make this argument, but what is Mr. Kratz's objection?
Mr. Kratz?
These are voicemail messages that were retrieved. I think it's clear. And I think Mr. Buting knows from family members of Teresa Halbach after she was missing on the 2nd or 3rd or something like that. And Mr. Buting's position, if his theory of defense is that Teresa Halbach is alive on the 2nd of November, we're entitled to know that. We're entitled to notice of that. That's my objection, is that it's irrelevant. He is about to show her some retrieved voicemails on the 2nd. It absolutely is meant to mislead this jury, and I want an offer of proof, Judge.
Mr. Buting?
Mr. Kratz may draw the conclusion that because messages are open as of November 2nd, that means that Teresa Halbach was alive on that date. I don't. And I don't think the jury needs to either. But I do intend to introduce records that show that her voicemail was picked up at 8 a.m. on November 2nd and that she was not reported missing for 36 hours more. Somebody listened to her messages, waited 36 hours before she was reported missing. That's relevant, and this jury has a right to know it. And this witness will establish that through this exhibit that I am about to introduce.
I'm thrilled to hear how that's relevant, Judge. I'm thrilled to hear how, if Teresa's brother waited 24 hours to report her missing, how that has anything to do with whether
I'm not sure.
Whether
You will have to explain the relevance to me.
Somebody, I'm sorry.
I would like to know how, whether her brother waiting 24 hours to report her missing has anything to do with the fact and consequence. That is, whether Mr. Avery killed Teresa Habach.
Okay, Judge, what we have heard at the very beginning of this trial is that nobody reported this young woman missing until about 5 p.m. on Thursday, November 3rd. In fact, nobody even started calling each other or friends about it until sometime in the afternoon. I think one or two was the testimony from Mr. Pierce of November 3rd. Somebody listened to Teresa Habach's messages. They are open from October 31st through November 2nd at 8 a.m. This witness has established that you have to have a password to be able to do that. Somebody with a password listened to her phone messages, and yet no steps were taken, no other references. I'm not saying it's her brother. I don't know who it is, but I do know that the police have had this report in their custody, and it's another example of the police investigative bias by their failure to follow up on this. There's a lot of unanswered questions about what was happening in Teresa Habach's life in those last few days, and why there is this kind of a delayed report. And here we have evidence that should have directed their investigation further, and it's pretty obvious now to hear Mr. Kratz that it wasn't done.
Mr. Kratz.
I invite the court to also look at 904.03. If there is any probative value, it is substantially outweighed by the danger of unfair prejudice. But also, more than that, the danger of confusion to this jury to the real issues is the case. If, in fact, Mr. Buting is suggesting, which I think is the only reason for this, that Ms. Habach may not have perished on the 31st of October, that it doesn't go to law enforcement bias, since Mr. Buting can't tie this up with law enforcement, 904.03. If nothing else, Judge, should exclude this particular evidence.
I don't recall if there was testimony earlier about someone retrieving her phone message earlier or not. Has there been any testimony about that in the record?
There was testimony that someone retrieved her messages on the evening of November 3rd.
They got a phone bill to look at who she called on the 3rd.
I believe somebody listened to the message, but they didn't.
That may be.
There is no confusion. There is no unfair prejudice. I don't see any way the state is prejudiced by this. This is just simply a phone record that will attempt to establish something that was going on with this phone in a very, very critical period of time for this trial, which is between October 31st and November 5th, when her car was found on November 3rd, when she was found missing.
How does that help this jury decide who killed her? That's what the jury is here to do, Judge.
Unless the state is prepared to establish that Mr. Avery had her password, then he's not the one who is listening to her messages on Wednesday, November 2nd at 8 a.m.
You said
somebody who knew her, somebody who may have had a motive that he doesn't have, and somebody who may have had opportunity was doing that.
Sounds like
I'm not suggesting that
third-party liability, Judge.
She was still alive.
That's what it sounds like.
I don't.
No, but I'm saying, I'm not just going to argue that part to the jury, because that's not what the court says we're going to do. But as far as what's relevant is, the police have had this report, and the police have not followed up to find out what's going on here. Who was accessing Teresa Habach's phone mail on November 2nd at 8 a.m.? Either she was alive and doing it herself, or somebody who had a password to her voicemail was doing it. It's got to be one of the two. And I have a right to introduce this to the jury as another example of how the focus was all on Mr. Avery. And they knew Mr. Avery didn't have the password. So, and their testimony is that he's already destroyed the phone. So again, this is an investigative lead that could be critical, that the state has, the prosecution and police have not followed up. And the jury has a right to see that it's part of this defense. I obviously will limit, we're not going to get into motive. I will limit it to that.
Does the state know who accessed the voicemail?
I suppose if there was an inkling that Mr. Buting was going to suggest that Ms. Halbach was alive at that time, this is something that could have been looked into investigatively. That's another thing that we can do if the defense is once again changing its theory.
This is not changing the theory at all. This fits perfectly to show that they have not followed up this investigative lead, because this investigative lead points elsewhere than Mr. Avery. Doesn't fit with their theory. And here we are in the middle of the trial, and it hasn't been investigated. The jury has the right to know that.
All right, I'm, I guess, having trouble tying its relevance or prohibitive value. I'm not going to allow it at this time, but I'm not going to automatically exclude it either. I want a little time to think about it. It will give the state some time to see if they have an explanation for who listened to it or under what circumstances someone listened to it. But I'm having trouble seeing the apparent relevance of it at this stage in the trial. Let's bring the jurors back in. Do I take it you have another technical person from Singular who's going to be testifying?
No, that's what Ms. DOHRWARDT was for, Judge. She's that technical person who is able to testify about the cell sites and about there was no cell site that this hit off of, and explain what that means, the significance of that.
All right, you may be seated. Mr. Buting, you may continue.
Just a couple of other questions I need to ask you. Are you familiar with the singularwireless.com access site?
Yes.
A customer can go online and access information about their account.
Yes.
To do that, you type in the website. When you get to the website, you have to put in a username and a password, right?
Right. You have to first set up the account.
Okay. So in order to access those records, someone would have to know the username and password, right?
Yes.
And before you can find out online who's making or what calls someone has been making on a particular Singular account, you would have to get past that screen.
Yes.
That requires a username and a password.
Yes.
There's no other way for me or anyone else to find out who you've been calling on your account, as an example.
Right.
And in Teresa Halbach's case, the focus here, since I don't know if it's a different type of account, but to your knowledge, for one to access Teresa Halbach's wireless account and find out who was calling her or who she called on October 31st, one would have to enter a username and a password.
Yes.
Okay. All right. Maybe I better put this up on the Elmo so the jury can follow. I just put up exhibit back on the Elmo again, Judge. That's got numbers.
It has numbers? Is that going to be the first one you put up there?
Yes, that will be the first one.
All right. Then the TV camera is instructed not to show the screen for the next exhibit.
Exhibit 361 is now on the screen, correct? Is that correct, ma'am?
Yes.
Okay, I'm sorry. And this is the record that you were testifying about on direct as to the information on Teresa Halbach's wireless account.
Yes.
I'm going to zoom it in a little bit because it's hard to see here. But for instance, what would be the second column? It says call date, call time. It's got dialed number duration, etc., right?
Yes.
Okay. And this column that says dialed number has a lot of blanks in between the numbers. It's got some numbers there, and there are some that are blank, right?
Yes.
And even the numbers that are there don't give a name, right?
Right.
So this document doesn't really tell you who made a call, for instance, at 12:29:08 p.m. that lasted 40 seconds.
Correct.
And this document doesn't tell you whose number is 755-8715, does it?
Correct.
So Exhibit 362, where it says sent and received and has a whole lot of names in it, how did you get those names? How did you tie those names to any of these numbers or to any of these calls, I should say, since some of them don't even have numbers?
Judge, that's a summary exhibit. This witness did not create. I think that's been established.
I'm going to excuse the jury again for a couple of minutes here. The witness may stay.
Hey, do I take that down or leave it up?
You can leave it up. You may be seated. Counsel, maybe I'm missing something here. But if the parties agreed to have the exhibits that only had names and not numbers, I guess I don't understand the significance of questions that are asking why these exhibits show numbers and not names.
Judge, let me clarify. I misspoke when I mentioned that one that's up there that has the 755 number. My question is as to the ones that are blank, where there is no phone number, some of which are on this exhibit, I believe.
I understand that. I wasn't second guessing that. But this is not the first time we have had some question about why the summary exhibits show names, but the phone records show only numbers. And I think it's unfair to suggest to the jury that there's anything untoward about that if the parties have agreed that they want the summary exhibits to show names and not numbers.
The court directed us to do this, and that's why this exhibit was created. We were in chambers and the defense agreed. There's not a stipulation. That's great. Let us know.
Bear with me just one moment, Your Honor. Judge, I think we have this worked out. I apologize. The summary exhibit includes phone numbers from other records and other exhibits that have already been introduced. This witness doesn't know that. I just want to clarify through this witness that the absence of numbers on this exhibit where it says dialed numbers in, that doesn't, for instance, mean that there's a *67 call or anything like that. The absence of those numbers is just because, as I understand, they're not singular customers. Is that right?
The absence of the numbers dialed? You mean, are you talking about like on just the missing numbers?
Right.
Those would be *67 or incoming call.
Oh, so
in our records, incoming calls are not shown.
Unless they are a singular person. If they are a singular person, do they show up on incoming?
No.
Oh.
No incoming calls show on the record, just the outgoing calls.
*67 or otherwise.
Right.
Okay, we'll just clarify that point for the jury.
Right.
And we'll also explain.
I think counsel should explain to the jurors that those summary exhibits have names and not numbers because the parties agreed that's how it's going to be done. Now, if there's any disagreement about a number matching a name, that's a separate issue, but assuming that there's no disagreement about that, I think that should be clarified for the jury.
I would appreciate it. Thank you.
Who wants to do it?
We will.
Very well. Alright, let's bring the jurors back in. You may be seated. Members of the jury, I apologise for the extra exercise we have been giving you this afternoon. There was an issue about the use of telephone numbers and the names of the persons associated with those numbers, and I believe the attorneys wish to put a stipulation on the record for you.
Judge, we have agreed that the summary exhibits, which would be 362 and 360, would not include phone numbers of the persons called or calling in for privacy reasons, and the summary exhibits would be substituted with the names of the parties. And having had some discussion now, we clarified that this witness doesn't actually know all the information that's on 362 because some of that information comes from other exhibits. So that explains some of the confusion that we're having.
All right, Mr. Kratz.
Judge, I just wanted to include in that stipulation that the court and the attorneys have been asked to substitute what would have been phone numbers for names. Exhibit number 360 and 362 were created by the state at the suggestion of the court and the acquiescence of the defense. We believed those to be, and still believe them to be, accurate reflections of not only the type of calls, the times, and the durations of the calls. If there continues to be any questions about that, we will call other witnesses to explain them. But with Mr. Buting's acknowledgement that there was a confusion, at least with this witness and perhaps with others, we hope that that explanation for the jury suffices, and that 360 and 362 can be admitted as exhibits, as if approved by summary exhibits. And if there are any further questions, those can certainly be asked, but certainly there shouldn't be any further question as to the authenticity or accuracy of these two exhibits.
Judge, just so we're clear, we're stipulating as to the sent-received column, the names that are there. We still do dispute because the exhibits are inconsistent as to the 4:35 p.m. phone call, one of which says the duration is 0 seconds, and another exhibit says 13 seconds. So with that, otherwise, we don't have a problem with these two exhibits.
I understand that, and we may recall that witness.
Okay.
Just to explain that one call, Judge.
Very well. Mr. Buting, do you have further questions?
Just one or two last ones. Exhibit 361, which is still on the screen here, just so we're clear, the dialed number column there that has some phone numbers and also has some blanks.
Yes.
The ones that are blank are not blank because somebody uses the *67 necessarily, right?
Correct.
Those are simply all incoming calls of any sort. Singular doesn't print out the phone numbers.
Correct.
All right. That's all I have.
All right. Anything else from the state?
Not of this witness. I will recall Miss DOHRWARDT.
This witness, you are excused, and then we'll allow the state to recall Mrs. DOHRWARDT. You may be seated, and Mrs. DOHRWARDT, you are still under oath. Mr. Kratz?
Thank you. Miss DOHRWARDT, the exhibit that is now being shown, exhibit number 361. You see a column that's called I sell. Do you see that?
Yes.
Do you know what that column represents?
I don't know for a fact, but by cell and the numbers, I would interpret that to be cell site numbers.
All right. So the jury...
Objection, Your Honor. If she doesn't know, she doesn't know.
Mr. Kratz?
I can ask her what cell site numbers are and how she believes that column relates to that, Judge. I would be happy to do that. Or I can call somebody from the Department of Justice. We can do it either way.
Well, you may ask additional foundational questions if you believe it will help.
I do. Ms. DOHRWARDT, what are cell sites?
Those would be the towers and sectors of towers. Ours are numbered. One tower could have up to 6 different numbers.
On a cellular telephone is used. How does that cellular telephone communicate with a cell tower?
By registration.
Does that happen?
There are certain events that cause registration.
Why don't you explain that for us if you can?
When a phone is powered on, it creates registration. When it makes or receives a call, it will show registration. Sends or receives a message, it will show registration. And when it's powered down, physically powered down, that would be the last registration, and it would show at the time that it was physically powered off.
And what can physically power off a telephone or a cell phone?
For where I'm talking, it would be holding the power button.
Okay. If a cellular phone is no longer operable, that is, if a cellular telephone is somehow destroyed, will it show that it is somehow off or powered down? Or will it continue to bounce off of or hit off of a cell tower?
No, it will no longer have a registration.
And if a cell phone no longer has a registration, that's two questions. First of all, can you still send a call, like a voicemail message to that particular cell phone?
Yes.
Physically, however, if it is no longer in service, if it's destroyed, as an example, could you physically answer or communicate with that cell phone?
No.
And do you know or do you have an opinion as to how that may be reflected in cell records, specifically in record number 361?
I believe that the numbers in the iCell column do represent cell site numbers that represent the cell site for each of those calls, and that at a point there is no longer any communication with the phone for the subsequent call.
Mr. Fallon can move that a little bit to the left. Are you able? To the left, Mr. Fallon. There you go. And up a little bit. The other way, Mr. Fallon. If I could see the cell site. There we go. Are you able now, looking at Exhibit 361, to see at which time is the last telephone call regarding this particular phone? Ms. Haubach's phone that actually was hitting or using a cell tower.
That would be the 2:41 p.m. call.
After 2:41 p.m. on the 31st of October, has Ms. Haubach's phone ever again, as this exhibit shows you, receive or send a phone message?
No.
So the 4:35 call, specifically, do you see that on there?
Yes.
Says 13 seconds, is that right?
Yes.
But do you see a cell tower that's associated with that?
No.
And what does that tell you?
That tells me that the duration was spent in voicemail.
That it wasn't. Does it tell you whether or not it was physically answered?
It could not have been. There's no cell site communicating with the phone for that call.
So if a cell call doesn't physically ever bounce off a tower, it can't physically ever be answered. Is that what you're saying?
Correct.
And is that the 4:35 call that is shown in exhibit number 361?
Yes.
And in fact, every call thereafter, that phone never bounces off a cell site, does it?
Correct. There's no registration.
That's all I have got, Judge. Thank you.
Mr. Beauty.
Just a couple of points of clarification. Sorry, I'm an idiot on this stuff. Bear with me. You said that when the phone is powered down, there is no registration, right?
There's an event that shows
okay
that it's physically powered down, and that we would see in the switch.
But you can't tell that from these records.
No.
Okay, if someone calls you when your phone is powered down, it goes into their phone still pings off of some sort of tower, right?
Who's theirs?
The calling party.
The calling party calling a powered down phone?
Sure.
Yes.
It still goes to a tower.
The calling phone, yes.
And then that tower, what searches for the receiving phone. If it doesn't find it, it goes to voicemail. Is that how it works?
It depends on whether you're same carrier or not same carrier that you're calling.
So here it was a phone call from your carrier that goes to a tower trying to reach a phone that's not answering it or not picking it up. Will it go to that other carrier's voicemail, or how does that work?
The other carrier's switch would have conditions or triggers that certain conditions are met, send the call to voicemail, such as no answer after 25 seconds.
Okay.
It knows the phone is powered off, and then it would send it immediately to voicemail, not 13 seconds typically.
Okay. So your best estimate is this probably went to voicemail.
Right.
As did the other ones after that.
Right.
And the only way to retrieve those messages, let's say if the phone was destroyed, somebody would have to be calling in on a landline and using and accessing that through a password.
Right. From any other phone, you can access voicemail.
With a password.
With a password?
All right, thank you.
Anything else?
No, Judge. I didn't know if those 4 exhibits had been received. I believe they have, but if not, I would offer them at this time.
Any objection at this time?
Yes, we can talk about. We do have an objection to the summary exhibits, but I think we can probably work that out with counsel during a break.
All right, I'm going to excuse the witness at this time. And members of the jury, I'm going to excuse you for the day as well. Remember not to discuss the case amongst yourselves or with anyone else. And make sure you do not watch any news media accounts of the case. We will see you tomorrow morning at the normal time. You may be seated. We're still on the record here. Counsel with 360 and 362, are you referring to the phone numbers that the defence may want to add to the exhibits or something else?
What we would like to do is, I think, talk to the state about modifying the exhibits. They may well agree. Just, to include the information that we want on and have elicited. There's no reason the jury would have to know that the exhibit has been modified. The jury hasn't seen 360 or 362. Assuming we can reach an agreement with the state, as I expect we will, then we would not have an objection to the admission of 360 or 362, and the jury can see them at that point.
All right, well, let's make sure to take that up first thing tomorrow morning. I would like to meet briefly with counsel in chambers before you leave today.
Judge, if I can just complete the record. 360 and 362 were both shown by Mr. Buting to the jury. I promised the court I wouldn't show them until we made any changes that there were going to be. I suspect none of them are going to pick up on that. And I don't have any objection to Mr. Buting and Mr. Strang and I trying to refine those exhibits. And if the court has no objection, and Madam Clerk doesn't as well, and we can come to some agreement, we'll simply stipulate. We'll simply substitute those exhibits.
I stand corrected. Mr. Buting says he did briefly swipe them past, but we'll see what we can work out.
All right,